George, why did you get in that bag? We drink a little wine, no one knows us.
He said, Sarah,
Sarah.
that's my name, don't wear it out. It's not intentional
Sarah
to
Boone
fall
needed a
asleep,
lawyer.
I swear.
Not malicious.
But he
I
said,
fell asleep.
Not malicious.
But then I fell asleep.
Sarah,
I fell asleep.
please won't you let
Because
me
it
out?
makes it sound like to me like I'm being accused of something that was not intentional. I'm being accused of it.
Not intentional, no
Right where it is.
malicious.
Right
She just
down
there.
fell asleep
You
and
did
played,
him.
forgot he was in the bag of dead and stuff. Not intentional.
And I
Not
can't
an
imagine
accident at
a
all.
system
It will all make sense when
pretends
she
it's an
takes a
aberration.
stand. Oh, Sarah, Sarah.
Now you all think that I had even more in quotes intent to do what I did, which was not intentional.
He said, Sarah, Sarah, that's my name, don't wear it out. It's not intentional to fall asleep, I swear. But he said, Sarah. But he said, Sarah. We said, Sarah, Sarah, Sarah.
Hello, everybody! Excited utterance here. My name's Hella, not Sarah. I might have had a little bit of fun making that. Had you noticed that when George was arrested, he said Sarah in a really kind of spookily similar way to the way he said it in the Suitcase? He said, Sarah, Sarah. Yeah, I know. It's interesting, isn't it? Interesting. We noticed that a few streams back when we were watching those body cams from prior to the incident. Today's a big day, guys. Today is the final pre-trial hearing. And we have guests. We have all sorts of fun things happening. First, let's say hello, bye friends. Let's go chat. Let's go chat. And Young Forever, hello. Sarah Young, yes. And we have Angela. Hello, Angela. Good to see you here. And Scott, and answer my question, Sean. He'll be here in a second. Oh, Kat, how are you? Going to be a little late tuning in. Love hearing you guys and can't wait to see this hearing. 5 gifted memberships from Kat, not Williams. Thank you so much. And we're adding that to the tally. We have 15 so far, and every time we have 25 new gifted memberships, I want you to see this background here, my pretty new background. Something new will be added to this background every time we get up to 25. Now we had 10 from Schnibbles, and we've had 5 now from Cat Not Williams. And I know we're not quite at trial yet, but I'm adding them up anyway because new things are going to get added. See, if you can see that we're in the apartment. We're in the apartment. Yeah, so new stuff's going to get added. Is this live? It might as well be, David. David's here too. And Mavka, yes, this is some hearing, guys. Just wait. Am I playing a song? There was a song. Hella streaming from a suitcase. Marsha, yes, it's a doozy. I watched the hearing live, but promise no spoilers. Whatever. It's fun. Oh, P. Lola's mum, I saw you over in the other chat. Don't trust me, it's going to be a different chat today. All right, let me bring in my guests. Let me bring people in. So let's see. I had to chuck some people out, but I'll bring them in. Here we go. Oh, hello.
Hey. Everywhere.
Hey, look at this.
You know what? The reason we're late is because Hella was in fact streaming from a suitcase and couldn't figure out how to get out. So,
I was, yeah, but I had to wriggle around a bit. That's my name, don't wear it out. We have Sean, potentially criminal. Hello, Sean, up there in the top right-hand corner. We have MLS,
Hello.
making law simple, in the bottom, just below him. Hi, guys. Welcome to our two lawyers today. 2 lawyers. Count them.
Wow.
Yeah, I'm
Count
excited.
them.
Yes.
Check it
I'm
out.
playing with cheap
wow.
Chinese knockoff Legos while I'm streaming Sarah. There's like, this is the perfect evening activity for me.
It is indeed. And look, we have Dali as well. Not to, like, play down the
okay.
fact that we have Dali. Dali's my
old school.
co-host.
He's or old news. He's boring now.
He's
I
old
know.
news.
That's fair.
And you never know. I've got invites out to some other people as well. So, and I have other circles ready to go.
All
So
right.
you just never know who might turn up.
Ricada might pop on.
You never know. Nick might pop on.
I'm just kidding.
So you might.
But that might make things interesting. We could put him in the suitcase as well.
Yes.
Oh my God, FMM 2.0 has gifted 10 Excited Utterance memberships. That means
That's awesome.
we are up to our first 25.
Hello,
Our
let me
very
ask you a
first
question.
25.
What's it like
Yes.
having members? Is it good? Does it feel nice?
Oh, David, that's so sad.
Any
That's
day
so
now.
sad. Having members is lovely. And you know what? Memberships is what keeps this channel going. Without them, I just couldn't keep doing this. And I appreciate every single member, especially those people who keep their memberships going every single month. Even when I had to take a bit of a break, you know, I had a death in the family, I had cats go missing, I had all sorts of things happen in my life. Those people who just kept those memberships going, I appreciate you guys so much. And especially also people who give out those gifted memberships. Thank you so much, Dina. I appreciate you so much, and you're just such a wonderful friend. And without you, I'm sure most of us would be lost, like you, Sean.
Very true.
And
Very true. You have no idea.
this is when you go, yes.
Very true.
Absolutely. Thank you so much, Dina. All right. Well, that means something new has to pop up on the screen. So whilst we're playing the hearing, I'll think about what that might be. Any suggestions from chat of what might need to be on the carpet there somewhere? Maybe you guys could help me with that. All right, let's get into it, guys. It's a huge hearing.
What kind of beer does she drink again? What was she drunk on? Was it wine? I can't remember.
It was wine.
Vodka, I thought.
She said wine. She said they
Okay.
drank a bottle of wine, I believe.
Oh yeah. Well, then I think
I
that's what you
believe.
need.
Oh, hello, Tanya Hill. Welcome. And yes, free membership for you. Spilled wine. Ooh, spilled wine. Maybe KLF. All right, let's get into it, guys. It's a big one. It took a little while to actually get moving, so let's just get through this.
I like speed watching trials or hearings.
Yeah, and that's why, or trials as well. See, that's why I'm going to be playing this at night, guys. So if you're interested in watching the trial on speed mode, every night from 6 p.m. Eastern, we're going to be watching it here, and no breaks, no lunch breaks, no sidebars,
All gas,
nothing like
Kat.
that. All
No
gas. That's it. That's it. No breaks.
I might also be here. For
And
most of
David's going to be here too. Yep. So guests, games. P.S. You stick around to the end and we play trivia. So you pay attention and you might end up on the leaderboard. And
I gotta pay
guys,
attention now. All right.
well, it's up to you. You can not pay attention and you can sort of fudge it and see how you go. But those
I
of
used
you
to do
guys
pretty
who have
well
been
in
around,
your trivia, just winging it.
yeah, you can wing it, but you won't win if you wing it. All right. So
Oh,
I
thank
gotta
you so
say,
much.
what's that? Oh, we got P. Lola's mum. Thanks for the handsome eye candy tonight. Is that
Rawr.
you, darling? Darling.
I don't know.
What are you
Ooh.
guys doing?
Thank you for the handsome eye candy tonight.
Well, that might be.
Well, you're
you,
welcome,
Sean.
Salvador. I bring it whenever I can just for you.
Thank you.
That
And
might
thank
be
you, P.
Sean.
Lawless.
Oh, it might be. P. Lola's mum is lovely. She rewatches the stream. She leaves lovely comments. She even watches it on Facebook and likes the streams over there. P. Lola's mum, thank you for all of your support. All right, let's keep going. They're just having a little chitty chat. Okay, let's get into it, guys. Come on. Maybe I'll boost it from here.
Rawr.
Oh,
Gordon, I'm ready when you are.
thank you. Come on, Christine.
You catch Trump half the state.
William J. for the state. James Owens for Sarah Boone.
Okay, it takes a little second for the sound to adjust itself.
Yeah.
Now, P.S. I have...
Good afternoon, everyone. This being good afternoon. If you can please state your full name and date of birth for the record for me.
Sarah Boone, 10-10-7-7.
Okay, we're here on several different matters, including a motion to suppress.
It
Specifically,
does adjust, guys.
the
Sorry for the ear bleeding.
motion to suppress defendant statements at OCSO filed September 24, 2024. The amended motion to suppress defendant statements at OCSO filed September 30, 2024. And then just what was filed this afternoon at 2:35 p.m., defendant's second amended motion to suppress defendant's
didn't know.
statements at OCSO. State, have you had the opportunity to review the second amended motion? Are you ready to proceed on that today? Okay. Are there any housekeeping matters we need to address from the state side of the ledger?
Not on that motion.
Okay. Any housekeeping matters on your side of the ledger, sir, with regard to those motions to suppress?
No, sir, Judge. I believe we've got the detectives outside to testify, and we've also got the custodian of records from the Orange County Sheriff's Department.
That's a whole evidentiary hearing, huh?
And the policy.
It's a
Is
little
that
bit like what?
a valid argument that you're still embarking on this afternoon based on what's in your second amended motion?
Yes.
Okay, so the sufficiency of the Miranda waiver is still at play?
Yes.
Okay, all right, thank you, sir. With regard to the other motions that were set for today, and I have reviewed the state's motion to strike, and I have reviewed all the case law authorities that y'all have provided to me as well. With regard to the defendant's motion for hair, cosmetics, civilian, and clothing without restraints for trial, Mr. J, do you have any position with regard to the restraints at trial portion of that motion?
It's
A lot of the case has already
glitching.
on that issue.
Okay, all right.
The
We'll
video?
entertain argument when we get there. And I've also reviewed the state's request for protective order filed September 30.
I
which is
can
also set
play
to
it
this
if you need.
afternoon. With that,
give
we'll
it a
begin
sec.
with the motions to suppress. State, you can call your first witness.
Judge, I'm not objecting to the authenticity of whatever it is he subpoenaed. I've been getting some of the documents, Orange County Sheriff's Office General Order 711. I don't see any need to belabor the custodian of records sitting around. Was there something else? Did you actually Miranda card? Or yeah, if you look in the very back,
Well, if you stipulate,
look in the very back. Okay. You see the Miranda card? The last page is the neck of the last page. Yeah, there's no need to keep the custodian of records around for authenticity. We still have our objections.
Okay, all right. Can the custodian then be released by virtue of the state's stipulation as to that, those records?
Yes, can I go tell what you do?
Yes.
2 seconds, guys. I'm just fixing something up.
what are you doing?
What am I doing?
I also have reviewed the 2 hour and 6 minute investigation.
Ooh, did we
that's
play the
pertinent
whole
to-
thing?
To the motion to suppress.
He watched
I
the whole
reviewed
thing,
entire
yeah.
video.
He
With
watched
that,
it.
State, you may proceed.
State would ask the court for the clerk to mark A for identification of his DVD, birthday copy, body worn camera.
It was a little choppy and ruiny at the beginning, guys.
Yeah.
It was
I thought that was Hella's
no.
internet.
Shouldn't be.
No.
Australian.
Well, she has had issues, so.
I've had a couple
I
of
have
issues, but I
reviewed all
fixed
of
them
those
up.
in advance of today's hearing.
No, I do not envy this guy.
Any objections?
No
This is
objection?
What was
Boone's
pre-marked as
attorney.
States A will be received into
He's
evidence
doing
without objection
great.
as States 1.
Yeah, it's a lot of work, though. I mean, he is busting his ass, and I want everyone to appreciate that.
They don't.
No, they don't.
Nobody does.
No,
They're calling him.
yeah,
They're calling him evil.
and unprepared.
Yeah, unprepared
The
in
people
this
that have no fucking
situation.
clue what they're talking about.
No, they don't. Oh, thank you, beautiful. Oh, hey, Garrett. Yeah, I'm just checking my internet packets, Brad.
Yeah, I think
Good
it's
afternoon, ma'am. Could you state your full name for the record and spell it for us?
Chelsea Castle.
Officer Cutie.
S-E-Y. Last name is K-O.
What? Did you say that before you saw her face?
Thank you.
Oh,
Counselor Unicorn.
P.S. By the
working?
way, this chick, she is the chick who was interviewing Sarah.
Mm-hmm.
How can you believe it? Look at her. She's hot. What happened to
That
her?
she?
Well,
That's not the
not
same
there.
person.
Did she lose weight?
Yeah, that's
I think
what I'm
wasn't she pregnant at the time when all this
She was
happened?
pregnant. Like, okay, she was
Oh.
pregnant, but who is
She's a
that?
MILF.
How is that the same chick?
Oh my gosh, you guys.
What? Oh my god, you guys, look at her. How is that the
She
same
doesn't know.
chick?
Excited doesn't have kids. She doesn't know.
I have one kid.
I know.
Okay, look, okay, so, yeah, okay, 3 or 4 years later, I looked the same as I did before I had a kid, and, like, having a kid wrecks you. Like,
Tell me about it.
Like, but I had to go, I had to go through, like, a lot of, like, diet and exercise and everything to get myself back to where I was before having a kid. But, like, in that interview room, at that time, she did not look like that. Like, I was
gonna
not
say,
expecting.
Why are you judging her by her looks?
Yeah.
We can judge her by her job performance, and we'll get the same result.
No, I'm just really surprised. Like, I don't care what she looks like. I'm just really surprised that, like, she walked in and I was not expecting her to be Chelsea. Like, look at her. She's gorgeous. Like, good for her. Wow. And I don't care what she looks like. I just think I was just not expecting her to be her. Like, she's hot. Wow. Good for her. Yeah.
Well, we know what excited likes and looks for in the ladies.
Well, look, I mean, I wouldn't date her, but I mean, maybe if I was that way inclined.
She's the state.
But yeah, no, she's a prosecutor. So she's a
No,
cop,
see,
so-
no, it's just excited has the same idea I do. Just take them down from inside.
Yeah, she's just not though beautiful. Yeah, exactly. So I'm not interested. But yeah, I'm just really surprised. She looks not like she doesn't look like the chick from 4 years ago. She just doesn't look like her. I wasn't expecting that to be her.
Sheriff's Office.
And what do you do for Sheriff Mina?
Yeah, this. Have you
How long
checked
have
your
you been a
packets?
homicide detective?
Could you please try?
And what's your total experience with the Orange County Sheriff's Office in terms of years?
I'm going on 12 years.
Any prior law enforcement experience prior to joining the Sheriff's Office?
Dally's just going to take over the video.
And in the homicide unit, how is it that you get notified that you shall be the lead investigator on a case?
So, for this case specifically, my team was on call. Yes.
And each of the third weeks you will be on call?
Housekeeping matters on your side of the ledger, sir, with trial. All of
Oh, you're green now, Daniel. Very good.
These are the worst fucking instructions I've ever seen.
Last name is Koepsell.
Thank you. Counselor, your main court.
Thank you. Where do you work, ma'am?
The Orange County Sheriff's Office.
And what do you do for Sheriff Mina?
We're up to
I am
37:30.
detective.
How long have you been a homicide detective?
I'm at
Over 6
a
years.
different stream, but
And what's your total experience
Oh,
with the
you're on
Orange County
different
Sheriff's
stream?
Office
Yeah.
in
This
terms of
is
years?
I'm going on 12 years.
Any prior
Yeah.
law enforcement experience prior to joining
Sorry,
the
guys.
Sheriff's Office?
Having some trouble.
And in the homicide unit, how is it that you get notified that you shall be the lead investigator on a case?
So,
See, I keep him around for
for
a
this case
reason.
specifically, my team was on call that week for homicides. And so,
too low.
the deputy on the scene, notify the call center to notify the on-call homicide.
All right, and is it fair to say that you guys have 3 teams of 4?
Yes.
And each of the third weeks you will be on
Could you
call?
please move the captions to be
And then-
not under your head?
Through some other random distribution, it's determined who of the 4 will be the lead?
Correct.
And it was your turn to investigate the death of Jorge Torres?
Yes.
And you were
George.
notified of this on February 24th of 2020 in the afternoon?
Yes.
About what time were you notified?
I would have to look at the CAD sheet to recall directly, but I would assume within 30
Sorry about
minutes
the
to an hour,
audio, guys.
deputies
It's
being on
garbage.
All right, and do you
gets
go to the
better,
scene
don't
first,
worry.
or do you do anything else?
I'm worried.
You just want something with
This
the
particular
mic.
incident, I got my
Thanks,
partner,
Melody.
Detective Sarah Boone, and we headed out to the scene.
All right, and when you got to the scene, what did you do?
I met with the deputies there, and they kind of just briefed me on what was going on and what they responded to.
Did you do a walkthrough of the scene?
I did, yes.
And then was a search warrant drafted for the residence
Yes.
and later executed?
Correct.
Did you have any contact with somebody identified to you as Sarah Boone on the scene?
Yes,
Do you see Sarah Boone in the courtroom today?
I do.
Can you point out where she is and what she's wearing?
She's over here on my left, and she's wearing blue.
May the record reflect she's identified the defendant.
Record will so reflect.
When did you first have contact with her?
If I'm not mistaken, she was outside of the apartment when I got there. So once
Yeah,
I
she
spoke
was.
with deputies, I then went and introduced myself to her.
All right, and did you ask her any questions at this time as you guys are standing outside of the residence?
Not like detailed questions about like what happened, because I already was told by deputies what she had told them. So it's more just to like introduce myself and to let her know, you know, we're doing a search
Hi,
warrant.
I will be the one
and
arresting you.
Procedures of how we do things.
And when you respond to a scene, do you respond in plain clothes?
I do, yeah, like business professional.
Like what you're wearing?
Yes.
What are you
And
wearing?
when you made contact with her outside of her residence for this first contact, were you alone or was your partner Scott alone with you?
Ma'am.
I believe Scott was with me.
And was he also similarly dressed
your
in business
boyfriend?
casual?
Yes.
All right. And so how long was this initial interaction with Miss Boone?
Not long.
Ask him for it, Ken.
Maybe a couple minutes to a few minutes.
Okay. And this was out on the sidewalk in front of her home?
Yes, if I'm not mistaken, she was at a neighbor's residence, like sitting out on their like front porch area.
Do you recall what you asked her in this initial contact?
Do I recall what?
You asked her?
No.
Okay. So it was just a couple of minutes
No.
that you were there with her?
Yeah.
Okay.
She got the most
And
annoying
then,
voice.
what do you do after
Yeah, I don't
your
like
first
her voice.
contact with
It's
her?
making her ugly.
Yeah.
30-point system.
So once I did my walkthrough, we decided to go with a search warrant for the scene. So that was written by somebody else. And then once that was executed, we went in there further with CSIs.
Damn.
And then,
Bad news, guys. She's married.
What? She's got a kid. Have you found that out for sure, or was it? Oh,
Yeah,
look at you.
I found her Facebook page.
Yeah, but she's got a kid in there. for God's
Stalker,
sake.
man.
Jeez,
Stalker.
Dolly.
What? I'm just,
Sorry, chat.
I'm doing research.
She's
Wonder why I
taken-
get phone calls from the court when this guy starts filing media coverage notices on my case.
Yeah.
Did you? Sorry.
Okay.
we talked to Brian Boone, which was the ex-husband. And then I believe then sat Sarah into our unmarked vehicle and had a conversation with her.
Was that conversation in the unmarked vehicle
Okay, can
recorded?
you press pause for a second, please?
And can you describe this unmarked vehicle?
Yeah.
All right. Thank you, everybody, for the gifted memberships. We have had 25 gifted memberships since I announced this. And thank you to Dina Schnibbles and Kat Knott Williams for that. We now have some wine on the ground over there on the right-hand side.
That.
Yay, some spilt wine has appeared. It's the very first one of our overlays that is going to be... We're starting it for the trial early, right? There's going to be way more things. So every time we get to 25 gifted
like-
memberships, there's going to be more stuff. I feel
like I'm gonna have
the
to start
apartment's
breaking
going to
out
fill up.
Bottles of alcohol for this trial.
Yeah.
Yes,
David
and call the
spilled
court.
wine glass. Let's go. Let's go. Let's get the chat green and let's get more stuff into this
Yes.
background, guys. You just noticed the suitcase. We are in the suitcase. Cool. All right, sweet. Let's keep going.
Vehicle for the court?
At the time, I was in a unmarked Pathfinder, so it was like gray in color. Didn't look like it didn't say like law enforcement or police or anything on the exterior. And there were lights like inside.
So how
Where
is
did
Boone
everybody
to
sit
know
in
that
this Pathfinder?
you're an
I
officer?
sat in the driver's seat. Sarah sat in the front passenger seat, and Detective Scott Lowen sat in the back seat.
Did you have any conversation with her about the facts of the case or your investigation that wasn't recorded inside the car?
No.
And that was all recorded and turned over to the state attorney's office?
Yes.
And you announced the date and time of the start of this interview on that recording, did you not?
Correct. I did.
Okay. Is it fair to say that it had been about 3 or 4 hours since the initial call out for a 911?
Yeah, I would say, yeah, because I believe we started interviewing her right before 5 p.m.
And is there any particular reason for executing the search warrant and speaking to another witness or witnesses prior to interviewing Miss Boone?
Just based off the situation and what was happening.
Okay. Is it in any way unusual to gather evidence before talking to the last person to see a decedent alive?
No, of course not.
At some point during this day, which was February 24th of 2020, was her cellular phone device collected?
It was
And when was that?
that same day.
I mean, when time-wise in relation to talking to her?
Oh, Well, I noticed the phone was in the kitchen area, but I didn't touch anything until CSI's documented everything, photographs. So I don't think I really touched it until after I had talked to her about going through it.
Oh,
All right.
touched what?
And ultimately, was she placed under arrest on February 24th, 2020?
No.
After she got out of her car, was she free to remain on the scene or free to leave?
Oh,
I
she
go back
does
to
look a bit like Casey Anthony.
Prior to that, had she
Oh,
been
I
detained
knew I
and
liked
requested not to leave the scene?
One more time.
Prior to your interview with her in the car, had she been asked or ordered to stay on the scene?
Darling,
Not by me.
what is up with you?
What?
February
Because
25th,
you-
was there a second
you have
interview
a thing for,
conducted
like,
with you and Detective Lowen?
These
With Ms.
bad girls like Casey Anthony and Jody.
You only say that because I sent an email to Hannah Gutierrez today.
Oh, you did?
No, I plan to, but not today.
Oh,
Got to
okay.
raise her up on JPay. What can I say?
It's, since there was that screenshot of her with like the hair that looks just like this with like the flippy back thing.
Did you get her care package yet, Sal?
Not yet. I'm open soon. I'll see
It's
if I
the
can.
hair with the like the Farrah Fawcett sort of flippy.
Yeah.
That's it. You saw that screenshot of her like in the hearing.
I mean, she wasn't bad.
She
I think
did
you
look
need
pretty
to raise
there.
your standards a bit, so that's all I'm going to say.
Well, you didn't see her.
Yeah.
Yeah. You've had that one on your screensaver ever since, yeah?
Well, anyway.
Yes.
Prior to this interview, had her phone been extracted by any member of the digital forensics team at the Sheriff's Office?
Yes, and there's some honey buns.
Yes.
And had you reviewed some of the evidence on there?
Yes.
You had requested that Miss Boone come down to the Sheriff's Office rather
Is she
than
the one that says
you
we
returning
found your
to the
video,
scene?
Sarah?
Yes.
Can you explain that?
Yes.
It's more of a controlled
She
setting
is.
for law enforcement. We're able to audio and video record at the sheriff's office, and she had mentioned that she might not be staying at her apartment, and so I didn't want to go to the ex-husband's residence where her potential child was, so I just felt it was a more controlled setting at the sheriff's office.
All right. And when Miss Boone
Oh,
arrives at the
wow.
Sheriff's
Thank
Office,
you.
who goes down to greet her and where?
Hello, I am
Wow.
Shout. Welcome. I don't think I know you, and welcome to chat. You have gifted 10 Excited Utterance memberships. That is so kind of you. That means that we are 10 further along to the next 25. And I am Shout. If you want to give us an idea of what you would like to see in the apartment, you've already contributed part of the way there to it. So go ahead. Let us know. Welcome to chat. I hope you enjoy the coverage. Thank you so much for
Thank
being
you.
here and
Very
for your
generous.
generosity.
Much
Much
appreciated.
appreciated.
All right, now I'm going to get comfortable and
It
settle
was
in
not
for this
me.
stream.
But she would have gone in through, we have two entryways, so either on the record side or on the opposite side. And she would have to go up to a window and request that she was there to meet with me. They would call me. I would tell them yes, sign her in. And then, if I'm not mistaken, I believe Scott, Detective Lowen, went down and got her.
All right, so you're describing two separate entrances that members of the public can come and go through,
Yes.
as opposed to separate entrances that might be in the back of your building where people are not free to come in and out of without a swipe card.
Yeah. The public doesn't have access.
All right. Now, in relationship to those two entrances, which I assume are on the first floor of the building, is that a safe assumption?
Yes.
Where are the CID or the investigation division's interview rooms?
They are located upstairs.
All right. And is she allowed to just walk up to the second floor interview room, or does she have to be with an employee of the sheriff's office?
She would have to be with an employee of the sheriff's office.
And your testimony is it wasn't you.
Then I don't believe so, no.
Now tell us about these interview rooms.
We have 4 interview rooms that are audio and video recorded.
Okay. And they have, you said they're video recorded. Was the interview with Ms. Boone video recorded by the sheriff's office equipment?
Yes.
Was there any conversation about the case or the investigation with her that did not occur inside that room with the recording going?
No.
Okay. I don't know the questions of this witness.
Thank you. Any cross-examination?
Yes. Detective, I'm James Owens. I met you outside just a few minutes ago, and you know I represent Sarah Boone. Detective, have
She's
you
like,
had a
"I
chance
know."
to review any paperwork related to this case prior to this hearing?
I have looked at my investigative report. And I have looked at some policies, but they were from current.
All right. Have you had a chance to view Deputy Kayla Rodriguez's body cam video prior to today?
I've seen it. I have not seen it recently.
Have you had a chance to review and listen to the audio interrogation that was in the unmarked vehicle that you did of Sarah Boone on the day in question?
Yes, I have reviewed that.
And have you had a chance to review the approximate 2-hour interrogation video at the Orange County Sheriff's Department?
Yes.
Dolly?
It'd be fair to say that prior to you...
Okay, so, hey Zach, if MLS tries to show you his yoga couch, just say no.
You know what,
does
Zach?
that
I'm
mean?
reserving that for you. Just for you. It's for you and me only. I don't share that with others.
Yeah, he doesn't disclose confidence, John.
This sounds a little bit festive. What do you mean? What's the yoga couch?
You don't know what a yoga couch is? Okay. It's
Should
used
I
for
know?
things other than for yoga.
I
Let's just say it puts the hips in the right position.
For what?
Oh,
Oh,
the
for stretching.
position.
I see.
Yeah, for stretching.
For
Okay, that's
opening
good.
up the the hip area.
The hip area, yeah.
Yeah.
Yes.
Betty splits or whatever.
I see. If MLS tries to show, okay, so it's just for you. It's just for you, Zach. Apparently, Zach Gallery.
Yeah, he knows that.
He
knows
knows
our
that.
special relationship.
Okay, right. Where does Zach live? Is it near you? Is he close to
Zach's
the Michigan area?
Zach's a wanderer. He's a traveler. He gets around.
Okay. He gets around. Thank you for the $1.99 super chat, Zach. And also, whilst we are here, Snivels.
Oh, wow.
Snivels. With the 10 Excited Utterance membership, Snivels, I can always count on you, Snivels. Thank you very much. We are now only 5 more memberships away from the next thing appearing in the apartment. What could it be, I wonder? Snivels, you are just a wonderful supporter. I love having you around, and I love saying Snivels. Thank you so much. I wonder what the next thing is going to be. Love you so much. Okay, darling, let's keep going. Very generous.
Okay.
You asking Sarah Boone to enter this unmarked vehicle for this interrogation with Detective Lowen, that you did a preliminary investigation as to whether or not this was potentially a homicide.
Yes.
And you would have viewed the scene inside the apartment?
Yes.
And you would have spoken to Deputy Rodriguez about what she knew about the situation?
Yes.
And you would speak to Deputy Rodriguez about what Sarah Boone had said?
Correct.
And did you talk to any other people there about the situation prior to speaking with Sarah Boone about the facts in this case?
Just Brian Boone.
Okay. And was that conversation recorded with Brian Boone?
Yes.
And would that have been in your squad car?
Potentially. I didn't listen to that interview. I don't know if we interviewed him outside or in my car.
Was he Mirandized?
No.
Okay. So although he was at the scene when y'all showed up, he was not considered a suspect or person of interest?
No.
At some
Well, you
point,
don't
did you
show up, he
determine
could
that
have been.
Sarah Boone was a suspect or person of interest?
At some point, yes.
Tell us when that happened.
The next day.
Okay, so at the time of this event, your initial appearance there at the scene, which I understand you must have stayed 4 or 5 hours?
Probably.
Okay. At that point, at no time did y'all
What?
consider Sarah Boone a suspect?
Well, it's difficult to the way you're
It looks like Trump's hair.
A little.
asking,
Well, I
but
guess
she was
she
the
might
only one
actually have a
there.
bald spot.
She's claiming that no one else was there.
covered up.
So
Oh.
what I was being told would mean that she
She's
was the
working
only
hard.
person of interest in that situation. But due to not having the autopsy results, we just interviewed her initially, got her initial statement, and then pending, once the autopsy was completed the next morning, was when I already knew I was going to meet with her again to discuss the autopsy results. So then we had another interview with her where she was Mirandized, and she went to jail later that evening.
And while you were there on scene, I know at some point you saw her phone on the kitchen counter?
I did.
All right.
Or
And-
maybe on the microwave. It was somewhere in the kitchen.
All right, and at some point you went to Sarah Boone and you asked her for the password to open the phone.
We asked to go through her phone.
Did you ask Sarah Boone, can I have the password so I can go through your phone?
Yes, after she signed the consent form.
Okay, so not before? You didn't ask her before you asked her to sign the consent form? Sarah, give me the password to your phone.
Not that I recall, but why would I would normally have her sign the consent form first for her consenting to go into the phone and then gather the passcode or whatever it is.
Well, how would that have even come about then? I mean, how would you have approached her about signing the waiver to consent to searching the phone?
She called 911, so I told her that we needed to corroborate her story as to what occurred.
Okay.
And so to do that, I wanted to go through her phone.
All right, do you know about what time she signed the consent?
No, I don't think it requires a time on there. But it was when we were on the scene initially.
Was it prior to her interrogation in the unmarked vehicle?
Yes.
And after she signed the consent, your testimony is you asked her for her password and she gave you her password after signing the consent to search the phone?
Yes, I didn't touch the phone until my digital came.
All right. You're talking about the digital investigator? And they have the ability to open up the phone and search the phone?
With or without a password, yes.
But y'all utilized the password that Sarah had given, had you not?
I believe so.
Okay. And do you know how long it took for the digital investigator to show up after you arrived?
Oh, yeah, she didn't come until later. I believe around 7 p.m.
Okay.
That's when in the CAD she arrived.
And you know there were two videos on Sarah's phone.
After I spoke to Sarah.
I'm sorry?
After I spoke to Sarah?
All right, so what I'm gathering from what you just said is at some point you asked or directed Sarah Boone into your unmarked vehicle where you interrogated her. Is that correct?
Where we completed an interview? Yes, sir.
And your testimony is that you did not view the videos that were found on her phone, and I'm referring to the 2-minute video of George in the suitcase. And then some time went by, and I think there was about a 22-second video of George in the suitcase
Only
that
2
Sarah
minutes.
took of him in the suitcase. Your testimony is prior to you putting her in your unmarked vehicle that you were not aware of those 2 videos.
That's correct, sir. I did not go through her phone until digital forensics came out and then went into her phone. And then she brought me over to her van to tell me about the videos and what she found.
All right, so your testimony is at the time that Sarah Boone was interviewed in your vehicle, that the forensic phone investigator had not arrived.
Correct.
Okay. Did you tell Sarah, I know we saw the audio once you get in the car, but did you talk to
Can you
Sarah
just pause for a second? I want to ask the lawyer
before y'all
something.
got in the vehicle?
Oh, shoot, I'm sorry.
guys.
Oh, sorry.
No, you're right. I was wondering about this earlier. Is he trying to get the videos thrown out as well?
I mean,
At
because
this
that would
point?
be her statement. So, yeah, the videos would get tossed too.
Yeah.
Because that's the recording of the interview is that. So it wouldn't just be her saying, here's what Sarah told me, but also
Yeah.
being able to play the interview, because if it was illegal to talk to her, it's illegal to have recorded it.
Well, no, they're specifically referencing the videos that she took.
I
phone.
don't know. Not at this point. No. I'm sorry. Oh, the video Sarah took. Yeah, no.
Yeah,
Not
I
here.
think he's just trying to see where he can poke some holes maybe going forward.
Yeah, I'm
use-
sorry, Hella. I was being a tard there. No, that's going to be like a motion in limine.
Okay.
Because you can't
Yeah.
suppress those because
But this
Sarah
is-
took them. You could suppress maybe how they retrieved them, but he's not doing that.
The other thing you want to think about here too is that in criminal proceedings, I don't know how Florida is. It doesn't sound like there's depositions of these defendants, and in most criminal proceedings, the only opportunity
No.
you get to really examine the witnesses is when you happen to get them on the stand. So you
Florida is
you might-
very deposition friendly.
even in criminal cases,
Oh yeah.
but there hasn't been depositions taken of this woman.
No, but the other parties have. Like
Yeah.
other people in the case have. But yeah,
Other
you're
lawyers.
generally deposing a detective. You might not get it. You're gonna have to ask for it. But yes, you're overall yes. The amount of information you're gonna get is limited until you're really at trial.
So, well,
Bringing
my
it up
point
there.
is you should start poking around some things and see what the
But-
responses are because you get limited opportunities.
And you can use it for impeachment in the future.
Yes.
Yep.
And keep watching because that's going to become an issue.
Okay.
Yeah, because I mean, when I saw this when I was half asleep, and I noticed him asking her, like, did you get her consent before you saw these videos, and did you
Yeah.
did
So-
you give
so-
it to the
That'd be
Sorry, go ahead.
that'd be based for a motion in limiting to
Yep.
exclude those videos going forward, like Sean was talking about. But you establish like, so if there wasn't consent and there wasn't a warrant and there was no probable cause to search, then all of that is fruit of the poisonous tree and it gets kicked.
Yes.
So that's what they're going at. Yeah. So he's taking this opportunity to just poke around and see what he could get.
And judge is kind of letting him because he kind of understands like this is it.
Yeah, exactly. That's what I was thinking. Fruit of the poisonous tree, kind of like the IGG in Koberger.
Yeah, this motion, just to set the table, this motion is all about the statement she made in the interrogation room. It's not about the things that she said on the videos that she recorded. But he's going to take this opportunity. I would. He's doing a good job.
Yeah, he's doing fantastic. And I saw this and I was just
I love the duck face.
Wow.
It's so cute.
He does have Sarah's expression.
It's a good pause. But yeah.
Salvador's already captured the screen image. He's going to go to bed with it.
He's very good. This guy he's poking holes in places where people just aren't noticing. They're just like, they say, what is he talking about? This is irrelevant. It's useless. No, he could get those videos, very important videos.
Yeah.
Manny B, even if this gets denied by this judge, it doesn't mean that it's not right for appellate issues. So
that too.
Yep.
And he gets more information he can use in trial.
Yep.
Yeah.
I also want to see how she responds to cross-examination on questions she might not be anticipating. There's a lot of good information he's getting out of this.
How to rattle her.
He's doing fantastic. Okay, let's keep going.
That's very true as well. You find out how good she is on there's a lot of information you can get.
Especially if he's never even deposed her.
Yeah, and there's also...
That's what I'm seeing anyways.
Yeah. There's also the issue he might go, oh my God, she's bulletproof on the stand too. So
which I'm getting a sense of.
Yeah, this is not her first rodeo.
Yeah.
No.
You got that mom look.
Yeah.
Thanks, guys.
And did you tell Sarah that y'all wanted to talk to her and this was routine protocol?
Yeah, that I wanted to have a conversation with her, and once
Couple keys,
once I had
left some
come out of the house
A's.
and saw what I was working with, we would have that conversation.
Did you tell her that interviewing her in the squad car was routine protocol to your investigation?
I don't recall if I specifically said that, sir. This was 2020.
Okay. If she recalled that, would you dispute it?
Objection, improper question. Sustained.
Your testimony is you don't remember saying that.
I don't remember specifically saying what. One more time. What is it that she claimed that I said?
Routine protocol.
I would not interview her, not in my unmarked car. So my routine protocol, sure, I would do that. I would interview her in a spot where no one can hear us.
And you would explain to her why you were doing that, wouldn't you?
Would I explain to her why we were sitting in my car?
Yeah. Yes.
No.
Well, you would have to tell her something.
I said, yes, we're going to go have a conversation in my car now.
Okay. And did she have any questions that you recall about what's this about? And you could have potentially explained to her that this is routine?
It was all explained on the audio recording.
Okay. But you had a conversation
Why
with
do you
her
want to
before
talk
you
to
got
me?
into the car with her.
Yes, I definitely directed her to get into the front passenger seat when we were going to talk in the vehicle, yes.
Okay. And you don't recall whether or not you said this is routine protocol to come into the car and talk to me?
Those words specifically, no. But I would have talked to her in the vehicle regardless. I would not have talked to her outside of my vehicle.
Now, once inside the squad car, you were there with the other detective, Detective Lowen.
Correct.
Okay. And you read her the Miranda rights card, correct?
Yes.
Here we go.
Do you agree that you didn't ask her the last question, number 9?
Objection, relevance.
Response.
Judge, we're here on a hearing on the issue
why we're
about the
here.
interrogation.
Of the case law that you provided to me, none of it stands for the proposition. Miranda identifies the 4 things that need to be addressed. Not one of the cases talks about that issue of reading that language at the bottom of the card that is in the motion upon information and belief. This is what it says. So how's it relevant for the purposes of today?
Well, it's relevant because it's the policy of her department.
But Judge, what does the policy have? But now we're getting away from the card to now the policy. There's nothing about the policy right now. The question is about what the card says.
It's not going to work for me.
The card is the policy, and the policy is the policy. They're intertwined. They refer to each other. Our argument is that she did not waive her rights, but remain silent.
That's a different issue than what is on the card.
I understand, but it's a coercive question
Welcome to
about her
chat.
not
We all
doing
hate
that,
this
which was the
judge
policy of her sheriff's department. She elected not to do that. She wanted a statement from Sarah Boone
Wait, what is the
at the
last
scene.
question?
She wanted a statement from Sarah Boone at the sheriff's department. She
I'm
elected
covering
not
the
to answer a
comments.
question
Am I-
that the policy says read
Yeah.
verbatim.
How's
that possible?
Oh, it's gone now. But
What
I'll
is the
show you.
last question? Does it have to do with like, and you knowingly voluntarily waive these rights? Is that the last?
It was, I believe, something about what was said on the card, or did you say something on the card?
No, the question on the card, the last
Oh.
statement on the card that she did not read. Does it say, and you're knowingly waiving your rights, and you want to talk to me, or you want to make a statement to me?
I don't
Because-
think they said what's on the card yet.
Okay, that's what I was wondering, if that's what we're getting at here.
Yeah.
Verbatim from the card. Why did she not want it? Our position is it was an attempt by this detective to coerce Sarah Boone into talking.
Love.
On February 24th or on February 25th?
On February 25th. This
what I was thinking
interrogation
it was,
ties into
correct.
that one. She used the same routine protocol that she used for the second one. The first one, she claims that my client wasn't a suspect, wasn't a person of interest. At the sheriff's department, I'm
Ted
sure,
Cruz is
I haven't
not
talked to her about
pleased.
it yet, but I'm sure she's going to say, yes, she was a suspect. Yes, she was a person of interest. Yes, we had probable cause to arrest her prior to her giving a statement. But what she said in terms of routine protocol the day before was what Sarah was relying on when she said routine protocol, when she questioned the detective about routine protocol the very next day in the interrogation room. And for her not to give that question goes to the totality of the circumstances as to whether or not my client, Sarah Boone, actually waived her right to remain silent. If she understood her rights, and then she consciously and freely waived her rights. She was not asked that question. She was not asked that question in the car. She was not asked that question. But that totality of the circumstances comes into play for the court to consider, this court or an appellate court to consider, as to whether or not that statement should be suppressed.
Any other response?
Judge, just like it's irrelevant what the sheriff's office policy is compared to what the Florida case law says about our right to not be compelled to give statements under our Constitution in the state of Florida, or the United States and federal case law and the state case law interpreting the United States Constitution, the policy is irrelevant, and the officer's subjective intent is completely irrelevant in a motion to suppress, just like it would be in a traffic stop under Wren versus United States. What matters is objectively what was spoken to the defendant, and I would ask that we honor the local administrative order and call people by their
That's what he
surnames,
was
not their first
asking.
names.
If she asked the last question.
What matters is that the defendant was read what the case law requires. Anything about the policy, anything about the officer's subjective intent is completely outside of all the case law submitted by both parties.
Last bite at the apple.
I'm sorry?
Last bite at the apple. Last bite at the apple. Any other argument?
We're talking about the totality of the circumstances, whether it was coerced or not. You can take any technique or a non-technique, something that you use or don't use, to establish whether or not it was coerced or not. The fact that she didn't read, do you understand the rights? Do you understand these rights, which is the form, the Miranda warning form? Do you wish to talk to us at any time? That's on the waiver affidavit. On the other form, which is the policies form, it says, do you understand these rights? And then the question number 9, do you wish to talk to us at this time?
Objections overruled.
Thank you. And you're referring about surname. What do you mean by that? You mean,
That means last name.
okay, what did I say? This
You keep calling the defendant by her first name.
All right. Can I say Sarah Boone?
Either Miss Boone or Sarah Boone, that's fine.
Okay.
You may proceed.
Client. Okay.
Have you had a chance to look at the standardized Miranda card issued by the Orange County Sheriff's Office?
Does that make it any harder for him? He can't even call her Sarah. For crying out loud.
I don't know. I mean, I've seen in trials that the judges typically allow the defense counsel to call their clients by their first name.
I've never had an attorney or a judge tell me how to address my client.
He's
Yeah.
such a dick.
Yeah.
Like, seriously.
That's
I can't
really
stand
weird.
this dude. He's such a dick. He's just like, can I make it harder?
Yeah.
He gives him 3 weeks to freaking get to trial, and then he's like, oh, can you call it by her full
Well,
name,
he did.
please?
He did overrule the objection, and he allowed the question. Although I think he's allowing it just because he knows he's gonna deny the motion anyways on those grounds, and then there's no appellate issues.
Mm.
Hey, Steve,
Hey.
how are you, mate? How are you? If you want to pop on, you're more than welcome. If you just got home, though, and you're tired, I get it.
Yes.
You're always welcome. I'm going to send you a link every day, and I don't care if you can make it on or not. You're always welcome.
Yes.
Always welcome. Love you much.
Stephen, hello.
Do you agree that you did not read the 9 questions to her in your squad car?
That's
All
what
9
they meant by the
questions?
comment.
Correct.
No, I did not read all 9 questions.
Do you know how many questions you did read to her?
8.
Okay. And the question you omitted is question number 9.
Like
Is
the
that
number
correct?
of her attorneys.
Yes, it's actually not on my Miranda card, but continue.
One question
sorry?
for every
It's not on
attorney.
my Miranda card that I read from. But you can continue.
What do you mean by that? It was the card
You
that
can
you read, it was
continue.
not on the card?
Oh my God, the nerve of this
No,
woman.
not on my card.
Not on my card.
We have multiple Miranda cards at the sheriff's office, but yes, that is in reference to the policy. Yes, that is the policy.
Well, somebody
Oh.
dropped the ball somewhere. Did you fail to get
Proper question.
Sustained.
did you fail to get the most updated card, or how did that happen that the 9th question was not on your Miranda rights card?
I've had that card since I started being a detective in sex crimes in 2013.
Have you become aware, as it relates to filing this motion,
I've become more aware, yes, that there is that card.
have you gone and gotten the updated card?
Ooh, she's getting upset
Objection
about
relevant.
something.
Sustained.
Found some
No need
buttons
to
to
get
maybe
grumpy.
push in front of the jury.
This is good.
She knows she's in trouble.
At least it's not a good look.
When y'all took her
No.
phone, Detective, did you tell Sarah Boone that you would be returning to her apartment the following afternoon to give her her phone back?
No,
You did not tell her that.
no. I listened to all my interviews, everything that's been audio recorded. No, I did not tell her that. We had plans to meet at the sheriff's office.
Or tell me what you understood
Settle down.
the conversation was as it relates to her getting her phone back.
I'm sure she asked when she'd be getting her phone back, and I didn't give her a detailed timeline. I said that, I don't even know if I told her that I decided to write a search warrant on it because I don't need to tell her that. It's evidence in a crime. I'm allowed to take it, and so I took it, and I wrote a search warrant for it.
Okay.
Is this it?
But you don't recall ever having a
1.5,
discussion with Sarah Boone
2.5.
about when you were going to return her phone?
Specifically returning her phone, no.
Okay.
0.25.
Do you recall her calling you later that evening on your cell phone? From her husband's phone? You don't recall that conversation? She called you later that evening?
Do you
Did
have
she?
documentation of the phone call?
I have her testimony.
Oh, okay. Well, I don't recall the phone conversation.
Excuse me?
I do not recall the phone conversation.
Wonder why she called.
You said that y'all had some discussions about Sarah Boone coming to the station. Was that talked about the day of this event or the next day with Sarah Boone?
It was talked about before I left the scene.
All right. And did you relate to Sarah Boone that she needed to come to the sheriff's department the next day to retrieve her phone?
I don't know if I specifically told her about retrieving her phone, but she knew that I was waiting to hear about the autopsy results and that I would probably have more questions.
All right, so you believe you told her that night, I need you to come back, maybe or maybe not about the phone, but I may have some more questions for you?
Something along those lines, yeah.
Okay. And when was it that you actually saw the 2 videos from Sarah's phone? Was it that evening after the interrogation in the squad car?
I've already answered, but yes, it was after the interview.
All right, and was it while you were on scene?
Snippy,
Okay.
snippy.
And did you attempt to talk to
She's
Sarah
snippy.
again about that at that time?
Yeah.
Okay. And so did you let your detective partner know about the videos on Sarah's phone?
Objection relevant.
Overruled.
Did you let your partner know about that evidence? Okay. And did y'all discuss that issue?
Objection relevant work product.
Sustained.
At some point,
No,
y'all had to,
Dolly.
were y'all working together, or were you making all the calls, or were y'all making joint decisions?
Objection relevant work product.
Sustained.
Ma'am?
There's no.
That means
there's
we've got 4 left. Thank you,
At some
Dolly.
point, did you form an opinion as to whether you had probable cause to arrest Sarah Boone?
Objection
Yes,
relevant.
David, you'll remember.
no- Overruled.
Yes, at some point I did.
Did you make that decision? by
3
yourself,
left.
Or was it collectively made by others with the department?
Objection relevant.
Sustained. You don't need to answer anything.
Detective, at what point did y'all, that next day, I think you had her coming in the afternoon?
I believe it was around 3 p.m.
Did y'all work on trying to get the search warrant for the phone?
I got the search warrant for the phone, and I believe I submitted it that evening. I would have to look at it though.
Okay, do you know what time the search warrant came back signed by the judge?
It's documented in my investigator report, but I don't know off the top of
Okay. And would it be fair to say that you told Sarah to come in later that afternoon or the next day?
Yes.
Okay, and would it be fair to say that you worked on the case that entire day until Sarah Boone came in?
Yes, I attended an autopsy in the morning. That's why I asked her to come in at 3.
All right, and what time was the autopsy that morning?
It starts at 8, but I could probably get till 10. It takes quite a few hours.
2
Okay,
left.
and
I
were
had
you
to
there
sleep in.
alone with the medical examiner, or were there anybody else there?
I don't recall if Detective Lowen was with me or not, but yes, of course, there's doctors there.
Okay. And so in terms of your determination as to whether or not Sarah Boone was a suspect, did she become a suspect after you watched the video, the 2 videos from her phone the day before the autopsy?
Objection, relevance, the custody is not disputed on the February 25th statement.
How's this relevant? If the issue is knowing and intelligent waiver, the sufficiency of Miranda, and coercion, what does the formulation of probable cause have anything to do with anything?
Well, I wanted to bring out the fact that they had already made a decision before she came in for the interrogation on the 25th that they had probable cause to arrest her. So that if she, A, either didn't come in, they were going to go arrest her that day, or B, if she did come in and she exercised or invoked her rights to remain silent, that they were going to arrest her anyway. That they had already made a decision that she was the prime suspect. They had probable cause.
Establishing a custodial environment
that are
for the
raised in
purposes
motions.
of
It's whether or
Miranda.
not she was in custodial interrogation, whether she was free to leave.
I don't know that that's being disputed by the state.
Well, but he still has
That's
to
my understanding.
establish
The state's
it.
not disputing that there was a custodial interrogation, which is why
Stipulate to it.
on February 25th, which is why Miranda was provided prior to that.
Judge, it was
State
provided the day
hasn't
before,
stipulated
and
anything.
she's just testified she was free to leave at any time.
Okay.
So the Miranda was given on 2 separate occasions. She wasn't in custodial interrogation. Detective, am I right? The day.
Well, hang on. Before we ask any questions, let's drill with the evidentiary objection first. The objection sustained.
Okay.
You may proceed.
All right. Ma'am, you would agree that when Sarah Boone arrived that afternoon for the interrogation, she was not free to leave.
Can you please pause it for a second?
The state
Excuse
still
me,
didn't
pause it.
stipulate.
I believe they have. I believe the state's conceded it's a custodial interrogation.
Well, they did just then, I guess, maybe, sort of.
Well, I
but
think they did in the lead up to this. At the beginning, I believe they said, yeah, we'll stipulate that it was a custodial interrogation. It's just down
Okay.
to the knowing and voluntary waiver. So
Okay, all right.
Yeah.
Well, then that makes sense as to why it was sustained, but I didn't know that ahead of time.
Oh yeah,
And
no.
if they didn't-
I had to listen to it the first time. I got lost too.
Okay, all right, very good. Yeah, just if
It-
they didn't, if the state
Mhm.
didn't stipulate that it was a custodial interrogation, then he
Mhm.
has the burden of putting that on, and
Yeah.
so that's why I thought the objection was stupid.
Yeah, but I kind of get where he's going to, because it's still, you got to do the whole context. It's hard to skip that part when you're trying to set out everything he's saying. That she was in custody, therefore was she really voluntarily doing this?
Right.
You know, and I kind of get where he's going with that. And you know, here's the thing. I know Waterfall, yeah, he's doing his job, but he's still got to do it right. You know, like it's kind of like the idea of like when people make the argument of like, well, I don't see you doing it. It's like, you know, I could watch a guy slam a race car in a wall at 90 miles an hour and say, well, I don't see you doing that. I'm like, you're right. I wouldn't slam the car into the wall.
Yeah.
You know, it's like I wouldn't do something stupid.
I've said before, if this was like a year ago and
Mhm.
I, for some reason, you know, got a sponsor or something,
Yeah.
felt comfortable, I'd represent her in
Yep.
Florida, because I believe everyone's entitled to representation.
Yeah.
And I think he's doing a great job. He's poking the holes where he needs to
Yeah.
poke. So,
But well, like I said, don't worry. You might change your mind.
Well, I
so
mean,
far, so good.
Well, okay, so just in regard to this whole argument that is going on at the moment, Sean, are you saying that there's something that he's doing wrong? Like what?
Well, no. Just right now, it's just he's not really drilling onto the issue of did Sarah really understand and make a knowing, intelligent, voluntary waiver.
Okay.
I mean, you could argue that yes, she's in a custodial interrogation. Therefore, it's like all this pressures. You know, the idea. I think he's trying to set the scene. Like, there's all this pressure around her, and like the walls are closed in. You know, and like yes, you could argue that affects a knowing, intelligent, voluntary waiver. I've never made that personal argument myself, but I've said like the general vibe of a situation doesn't make it seem like it's there. But
Well,
normally you're arguing.
Sorry, go ahead.
What's that, David?
I was going to say the Supreme Court has touched on that
Yeah.
specifically,
Mhm.
especially with
Yeah.
that one bus case when the guy was, you know,
Yes.
confronted by the officers on the bus and he couldn't get past the officers, and that was held to be custodial.
Yeah.
So because of the environment around.
Yes,
the
and that's
impression
where
that-
custodial really becomes the issue: is the environment. Did you feel you could leave? Did you
Yes.
feel you had anywhere to go? But I get what he's trying to do. He's trying to like shoehorn in the vibe to did I feel like I could say no? And it's almost getting to not necessarily a coerced interrogation or a coerced confession, but a coerced acceptance of Miranda rights. And I
Yeah.
it's kind of like I get it. You got to run with what you got, and he don't got a lot to run with.
I don't like his position, his fundamental position that because they didn't read all the instructions on the card or follow the policy, therefore Miranda was violated. That's not the law, and I think the judge is right on that.
Yes, that's true.
Yeah, he's going with like a letter of the law argument.
That
so
being said, the last question, which is, do you knowingly, or do you understand these rights, and are you willing to still sit down and talk to us? That question not being asked is indicative of the fundamental issue is that she knowingly and voluntarily.
Yes.
So,
but yeah, the issue is you don't need that card, and the Supreme Court has said it's not a magic spell. You don't have to say it the right way.
Okay.
There's very few times in like the law, especially criminal law, you don't have to say magic spells. Like there is a magic word. I want a lawyer. That's a magic phrase.
Yeah. Yeah.
But other
She
than
should've said
that, well, yeah, but that is funny though. The police don't have to use magic words. We do as civilians, but yeah, you don't have to use specific words. They can, as long as they get across the point to you. Like the Chad Dorman case when they screwed up his Miranda warning.
Yes.
They had a different Miranda setup they were reading from, but they skipped a big part of it and they omitted a major part of it, but the rest of it was still valid.
Yes.
So sorry.
That's fair enough. And also I just want to mention before we finish this, hold on, Red. I'm no genius. Oops, no. I'm no genius. Wait. Dali, stop. Hold on, Red. A genius homicide detective, but I'm guessing she became a suspect when she said, I zipped him in the suitcase and he died in there. Well, yeah, that would be.
I mean, I believe
true.
she was a suspect when the 911 call was made. And
there's a death.
There's a dead guy in my apartment.
Yeah.
It's usually the person who calls 911.
A lot of times.
The person who finds the person deceased is generally the top suspect, unless there's a reason why not. Okay, so Aaron Olivia, thank you so much for becoming a YouTube member. Much appreciated. That's awesome. And Dali, thank you for gifting another Eastside Utterance membership. I think we're up to 25 now. That means I need to put something else onto the screen. Someone mentioned maybe some documents or what else?
I said a notebook and a pen.
A notebook and a pen? That sounds pretty good. If anyone else has got anything, any other ideas, cool. But yeah, I think I might, or maybe a Miranda card.
Yeah, there you go. That would be a good one, a Miranda card.
Yeah, maybe something like that. All right, I'll go find something to put on the page. Oh, and Darvel, thank you for the $1.99. Is it a sticker or just a donation? Thank you so much. Oh, a coloring book. Oh, yeah. All right, we'll find something. A book. Yes, she was reading a book in bed. Let's go find something. Let's keep going.
And so if she would have remained silent and exercised or invoked her right to remain silent, she would have been arrested anyway.
Correct.
And that was based on your investigation that you had the night before at the scene. And it was based on her statements that she had given you in the squad car. And it was based on the autopsy that was performed the next day that you were present for. And it was based on the 2 videotapes that you saw from Sarah's
Need to write all
phone.
these down.
Spectrum relevance as to what the probable cause basis sustained.
You had all that information before you began your interrogation on the 25th of Sarah Boone.
I had all that information.
All the information that I just related to you before you began your interrogation of Sarah Boone.
On February 25th?
That's correct.
Yes.
And you would agree that you wanted to speak to her on the 25th.
Objection, relevance.
Overruled.
Yes.
Okay. And would it be fair to say that you wanted to get statements from her relating to the injuries to Jorge Torres from the autopsy?
Objection, relevance.
Overruled.
Yes, I wanted to have a follow-up conversation in reference to what she told me the night before and in reference to the injuries that she failed to mention.
And you also wanted to question her about the 2 videotapes that you had found on the phone?
Objection, relevance.
Overruled.
Yes, I do want to show her the videos.
And you agree, in your opinion, the 2 videos and the autopsy were inconsistent with the story she had given you in the squad car the day before?
Objection, relevance.
Overruled.
The videos, I'm sorry, repeat your question one more time.
You would agree that the autopsy results and the videos that were extracted or taken from her phone, recording George, those two pieces of evidence from your investigation were inconsistent with a statement that she had given the day before in your squad car.
Same objection for the record.
Over.
Yes.
And I believe that's ultimately the reason you arrested her, because of her inconsistencies.
Objection. Irrelevant.
Sustained.
Now, you said you had a chance to review the interrogation video at the Orange County Jail on February 25th of 2020.
The Orange County Sheriff's Office.
Orange County Sheriff's Department. And also, I believe the state attorney had it transcribed. Have you had a chance to read the transcript?
I have not read the transcription. I watched the video with audio.
Okay. Have you had a chance to look at my motion where the question and answers are typed out, at least the first minute or so?
No, I've not looked at your motion.
Okay. Do you recall you saying to her, I'm going to have you sit in the green chair?
Objection. Best evidence is the recording.
He's right.
Ain't this best evidence?
Okay.
rule?
Objection sustained.
Okay.
Sean, do you ever come across that in Ohio?
Do you agree?
Sorry, what was that?
The best evidence rule? Like, oh,
Yeah.
yeah. I don't like it.
I mean,
It forces you to sit and watch a video, and the reason why I don't like it is because a video the jury falls asleep to. Now, granted, there's not a jury right now, but when you rely on the best evidence rule, it's like, well, just play the video. It's like, no, the jury's going to fall asleep, stop paying attention after the first 3 minutes. No, I want to ask questions of the witness. I hate the best evidence rule.
Can you explain that, please?
Oh no, go ahead, David.
No, I was just gonna. So what it is that if there's 2 forms of evidence, the question is what is the best way to convey what's the most accurate way to convey the information? The video speaks for itself is often the objection that you'll hear in Michigan. So if you question people about, did you say this in the video? Did that person say that in the video? It's like, well, why don't you just play the video?
Yeah.
Because then we don't have to, you're not guessing. You're not getting.
Or if there's a
phrase wrong.
document.
Yeah,
you
or
know,
if there's
like
a
we're talking
document.
about a contract, like why are we talking about what it says?
So you
in
just
the
let it in.
contract?
Yeah.
Yeah, that's the argument. It's like, why would we have, you tell me, like I'm the judge, I'm the jury. Why would we have you tell me what's in the paper instead of let me read the paper and then we could argue
That's
over
garbage.
what's on it?
Yeah, I don't like it because, especially when it comes to videos, because no one pays attention to the freaking videos. Again, you'll get like 3 minutes in, and then everyone's falling asleep. So
Yeah, and especially on that Sarah's interview, they're gonna.
Well, either that, or you're letting stuff in that not necessarily should be allowed in.
well, you can edit it and redact parts of it.
Oh yeah, you could. Yeah, and there's ways around that. And yes, if there's any problems with the evidence, you can object to it. But it's the general idea of like, why are we? It's kind of like when people on Twitter they make a claim, and I'm like, are you telling me what it says, or like, well then show me it. Don't tell me what it says. Show me the thing. Yeah. So there's times where I think it's helpful.
Yeah, I'm just not a fan of it all the time, like in this situation.
Yeah.
Wow. Okay. I've heard of it. I just didn't know that was what it meant.
It's like Rule 901.
Yeah.
Thanks.
Okay.
Prior to reading Miranda,
I'm pulling this one up.
that you mentioned to her that you had received his autopsy,
We're better than no.
that you were
We're
going to read
better.
her rights again, but that we had to talk about that, referring to the autopsy.
Best evidence.
Sustained.
Do you recall making some comments to her prior to reading her the rights?
Objection. Best evidence.
Overruled.
Yes.
Also, wait. If we pause it,
Is it the
didn't
policy?
he already watch the interview?
Statements.
He did.
The judge has already watched the interview, so I think it's not even best evidence at that point. It's judge, you've already seen it. Now they might argue asked and answered, or it's already been. You've already seen the evidence.
Yeah.
But I don't understand. That's not really and I've had time to think about it. That's not best evidence at that point. I would argue.
If he wants to get into further questions, such as why didn't you instruct her on this last thing, such as did you ever ask her whether or not she understood these rights, and did you ask her after you gave her the rights if she still wanted to continue to talk to you? Now, if your follow-up questions are those, you can just say, Judge, I'm just establishing foundation here for the next set of questions.
Yes.
He's not arguing that back yet, so we'll see.
Yeah,
where it
which
goes.
I think he just
sort of rolling over.
Okay.
to them about the interrogation prior to reading Miranda?
Objection, relevance.
Overruled.
One more time.
He doesn't remember the question.
The first time you've read Miranda to a suspect.
Objection, proper question.
I've been there before. That happens all the time.
Go back to the first question.
I know.
Is it the policy of the Sheriff's Department not to ask any preliminary questions prior to reading Miranda rights?
Same objection for the record.
Overruled as relevance.
You would have to show me the policy that you're referring to, but I was not asking her any incriminating questions during that time. I was explaining to her the purpose of the interview.
Well, have you ever been, I understand you must have undergone some training on Miranda rights and how to interrogate somebody.
Objection, proper.
No,
Sustained.
shade.
How long have you been with the Sheriff's Department?
Since 2013.
How long have you been a homicide detective?
Over 6 years.
Okay. Have you ever been trained or told to ask or not to ask any statements or any questions prior to reading Miranda relating to them talking to you?
Objection, relevance.
Sustained.
Can you tell us if you recall saying anything to her prior to reading her Miranda?
I recall briefly talking about getting the autopsy results, and I wish to have a conversation with her.
Do you recall again reading her Miranda rights to her on video?
Yes.
Do you recall again omitting question number 9 on the standardized Miranda rights form for the Orange County Sheriff's Office?
Objection, relevance.
Overruled.
I did not ask her question number 10.
Okay. Do they have a Miranda cards form in the interrogation room?
Yeah.
So you would have had that on your person?
Look how nice and friendly she was on direct examination. All these officers are like,
Yeah.
wow, this is 2.5 hour hearing.
Yeah, we're
Yeah,
going fast,
yeah.
so.
Yeah. It's only hour 15 left.
Yeah, but it's not. There was like a half-hour break at the beginning.
Yeah.
You may.
Okay, Kat, I get it.
I'm not going anywhere, half Irish.
Mary.
I gotta go for a run.
Yes, this is our waivers and affidavits.
No worries.
I'm gonna run in the dark.
Pick something.
It's filled out by me, but there's something highlighted that I did not do.
Okay. And was that form filled out as it relates to Sarah?
We're talking about just this top, right?
Well, suck it,
Okay, I'm
because
sorry.
it's not a good look for in front of the jury.
Form, is it filled out as it relates to Sarah?
Mm-hmm.
In case, yes.
Is that her signature on it?
Yes.
Did you see her sign it?
Yes.
Is that her signature on it?
Yes.
And is that the consent for the phone?
The consent to search, yes.
On that form, is there also the Miranda orders?
Yes.
That is a form that's standardized by the Sheriff's Department?
Yes.
And you did not read a Miranda from those rights?
From this piece of paper,
Yes.
that's audio and video recorded, that, no.
Okay, you would agree that there's non-questions on that form?
Yes.
Who would like to offer this?
Same objection to the relevance. As far as it being a consent to search her phone, we're not disputing that she was in custody on February 25th, 2020, when she gave a statement to the detectives. And again, under the case law, there's no requirement for this question 9. Under any state case law regarding the Florida state constitutional right to not be compelled to testify against oneself, nor any federal or state case law regarding the United States Constitution, the 5th Amendment applied to this state through the 14th Amendment that requires that question to be read. It does not go to the totality of the circumstances of the voluntariness of her waiver of her Miranda rights.
Good response.
Judge, obviously we disagree.
Then where's the case that supports that? Because as I addressed previously, I read all the authorities. I mean, State versus Owens,
Just a moment.
State v. Thomas, Powell from the
doesn't
United
mean
States
that
Supreme
it's
Court,
not
which reversed the
relevant.
Florida Supreme Court decision, all talk about what's required by Miranda. And that question number 9 that you're focusing on isn't included in any of those.
I understand that,
It's
Judge.
the right to remain silent, the right to an attorney, before and after questioning. If you can't afford one will be provided to you. Everything you say can and will
but
be used
there is
against you.
case law
Those are the
that
things that
you have to
Miranda highlights.
understand.
The Miranda opinion itself says that. So what does question number 9 have anything to do with those things if the state case law and the federal case law, including but not limited to Miranda itself and Powell, and then the state case law of Thomas and Owens, all of which were provided either by yourself or by the state, identify what's required, and that's not one of the requirements.
She has a duty to read the rights.
But they were.
I want to finish my argument.
Okay.
She has a duty to read the rights.
It's this judge.
She has an obligation to ensure that Sarah Boone understands her rights by asking that question. Do you understand the rights I just read? And then there must be a waiver. Yes, I understand the rights, and I agree to speak to you now. So for that to be freely and voluntarily given, that statement, there must be a conscious waiver of the rights. The problem with the detective is she reads the rights, do you understand the rights, and then she goes right into questioning. She goes right into questioning without saying, do you agree to speak to me? Understanding your rights, do you agree to speak to me now? That goes directly to whether or not it was freely, voluntarily, and knowingly given, the statement, and whether that waiver was. So under the totality of the circumstances, I think that evidence is relevant. It's the policy of the Sheriff's Department. Obviously, she had an old Miranda rights form, but she failed to read what we perceive as a critical question, and she's going to testify about what she perceived at the time that the detective failed to read that question and how it ties into the case. I understand that all they have to read is those 4, but I think under the totality of the circumstances standard that this court has to apply, that should be a consideration the court should consider. I know it was an honest mistake. She had an old card, but still, I feel like it should be considered in your decision.
Anything else, Mr. J?
It's essentially the defendant stating that they want to make new case law.
Do you?
I'm going to sustain the objection as
Pretty
relevance
much.
by virtue of the decisions
Yeah, but I don't
in
think it's
Thomas
like
351,
radical
731,
case law.
97, and Owens 41,
We're not in
733,
Barnes
52.
territory
There's-
Yeah.
it's not relevant as to what the questions need to be asked for the purposes of whether a sufficient Miranda waiver was given.
And this is where new case law starts, by the way. That's
Do you
the problem.
agree, detective, that after you read her those
Sarah Boone has
Miranda
already
rights.
won.
No, I think that's legitimate. I think the issue of whether or not she knowingly, voluntarily did it,
Uh-oh.
waived her rights, is relevant. Whether or not she read a particular statement, whether or not the card contains a particular statement, whether or not the knowing and voluntarily statement is within Miranda, none of that is relevant because it's not in Miranda, it's not in Powell, it's not required. But the issue of whether or not she knowingly and voluntarily waived it is
Situation.
that should be addressed.
Okay.
Play rocks and fix Sarah.
on the 25th, when you were reading her Miranda and about to question her, was different from the situation the day before when you read her Miranda in the squad car.
Thank you, Diego.
Yes, I had more evidence.
That was without the autopsy. That was without the 2 videos from her phone in the squad car.
Yeah, I did, at the time of the interview. Yes.
And in the squad car, she was free to leave.
I mean, I didn't tell her she was free to leave, but I mean, if she didn't want to talk to me, she didn't have to talk to me.
Okay.
This sound is horrible.
It is a. All right.
I mean, I don't think that he's going to win at all, but I like the arguments that are being made
Yeah, I
to
mean,
some extent. I don't like the fact that he's basing it all on procedures because that's nonsense. I don't like that
Yeah.
he's basing it on the cards because that's nonsense. But if he can get past that, I kind of
That's all the questions
understand
I have at this time.
the rest of
Any
it.
redirect?
Nothing.
All right. Can this witness be released?
I like what you're saying.
All right. Subject to recall. Thank you.
I'd like her to stay.
State, you may call your next witness.
No additional witnesses or evidence on this issue, Judge.
Okay.
Ooh,
Already,
here we
shit.
go.
Pause,
Anything from your side of the ledger, sir.
Pause.
Ah,
Pause. Get fucking ready. Get fucking ready.
Okay.
Yeah, I
hang on. Ready.
Hey, Zan.
Get fucking ready, chat.
Reach around.
I just got a feeling.
However you organized our soundboard.
Not intentional.
Ready?
Yes.
Let's go.
Let's go. All right. Let's see what happens next. I'm sure nothing out of the ordinary.
Nothing at all.
Would like-
no.
Where am I
You
walking?
stipulated to the introduction of your card.
No, I don't object to the authenticity.
All right, Judge, I would like to introduce. Maybe more cases.
Wait, what?
Introduce something.
Oh, okay.
Just that one.
Oh, is he going to call anybody?
And what is it that's been marked as Defense Exhibit B?
Judges,
These.
Any objection?
Same objection. It's irrelevant.
Is it the form as of now, or is it the form as of 2020 when the... Okay. Can I see it for a moment, please? Thank you. Any additional argument with regard to the state's relevance objection?
Same argument.
No, I'm sorry, Mr. J, I wasn't specific enough. Mr. Owens, to you. Any additional argument?
same argument, something.
All right, I'm going to sustain the relevancy objection for the same reasons the court articulated previously.
Is this like the form? The Miranda form?
Yeah.
And Mr. Owens, you had one additional exhibit as well?
This is composite exhibit, Judge, it's the policy of the Sheriff's Department. And it's a general
James, is there something you'd like to share with the rest of us?
Yeah, what's going on, James? Come on.
I just
Sarah
realized
Boone
we're
needs a
hanging out
lawyer.
with Suitcase, aren't we?
Do you know what page specifically those policies are on?
Page 14 of 22,
Meow.
I thought that was Sarah.
and I'll give you 2 more pages.
Is it beginning of paragraph 4, waiver of constitutional rights?
Yes,
You want me to skip
Sign a
forward a few
waiver?
seconds?
Did she sign a waiver?
Okay, calm down, cat. It's all right. It's
Is that
fine.
your cat?
Yep.
Is that or your kids screaming for help?
No, that's my cat. Hey, look, we have a document.
All right.
Let me scream, run, Clyde. No.
Okay, I've
wrong
read pages
continent.
14 and 15.
There are no Haitians in
Judge, and then,
Australia.
you go to 13 of 28.
13?
13,
Just
it's the
Aborigines.
next,
Oh, there's 2 different sets. It's a composite. My apologies.
it's split up.
Got it.
13 of 28 at the bottom, P. And then it goes on to the next page, 14 of 28. Specifically 2A on 14.
Okay, that's mean. Don't do that.
Ooh,
Sarah's thinking to herself, they're screwing me. The system is rigged.
Anything else?
No other argument, Judge, other than what we talked about.
Anything further?
Same arguments.
Okay.
Just treating me this way because I'm a white woman.
Objection as to relevance as to what was pre-marked as composite C. That will be received into evidence. Over objection is states 1. I'm sorry, defense is 1.
Okay.
Do you want to just flick forward until the thing
I
happens?
asked you like 30 seconds ago.
I'm sorry, I've been trying to fix something.
Any further witnesses, evidence, or testimony, sir?
Judge, I'd like to call Sarah Boone.
Hey!
Ms. Boone can approach the podium.
I knew this was coming. I didn't watch ahead. I was just like,
Didn't
everyone's
you?
like, get ready for this. I'm like, oh my
This
god, he's
is-
gonna call fucking Boone.
And here's the thing. The judge has already said, basically, there's You're flying in the face of everything that's been established anywhere in the country.
Why put your client at this risk?
So you already know. Well, that's what I mean. You already know you're dead. This argument's gonna fail. He's told you it's gonna fail. Why it's gonna fail? We're just wasting. You're running out the clock. And
client on the stand.
And here's the big thing, chat. Everything she says right now,
Yes.
against her in trial. This is testimony on the stand.
What if he wants to or Sarah wants to testify? And he is basically going to use this as a dry run.
I don't think Sarah has the right to say she wants to. She doesn't have the right to testify here.
No, she doesn't have to.
No, at trial.
Yeah, well,
I
this is,
get that.
This is still dangerous, though, because if you crash and burn here,
well,
game's over.
Yes, the prosecutor could perhaps get a little more leeway than would be he intended.
She doesn't have a right to testify here. This is completely within the attorney's hands. So this is the attorney doing it. This is one of those situations where, hey, client wants to testify, I can't stop them.
Yeah, there is no gain here.
Well, no,
the judge has already said you're toast, and it's not like he's got a decent argument.
You get to see Sarah on the stand. You get to see how she looks.
But now everybody's seen her on the stand, and once again, you know, if she crashes and burns, well, now you've got statements. Like her statement can be used against her.
But they were calling her. I'm excited.
Because it's kind of like that Toby Madison trial, or the Toby Madden trial. He said a bunch of shit on the, and the prosecutor can say, "Hey, guess what she's already said."
True.
Yeah.
I just think he's planning on calling her at the real trial.
He is. He said it.
Okay.
Which that's always never a good idea too, though.
Well,
well, they're going with self-defense, and my rule with self-defense is you're gonna have to get up on the stand.
You got to get up there.
Yeah.
Yep.
I agree, but
and
right
also
now it just doesn't matter.
Hey, Dr.
Well, it's going to give Sarah a lot of practice.
How are you?
Sorry, Sean. What were you saying?
I'm saying hi to Hines, but here's the thing: I can give her practice to cross-examination. I do this with my clients all the time. Are you ready? I sit them down. And we're like, okay, we're gonna start, and I let them actually run. I let them say whatever they think they're gonna say, and I just sit there as a prosecutor across from the table, and I just start being like, objection, and then I stop them, but I start peppering it's not exact. I start peppering them with questions. I mean, you can do this without going.
I've done.
I don't have to take you to the battlefield. I can sit there and shoot a gun over your head while you crawl along. I don't have to take you to the front to do this.
I've done mock trials with other attorneys coming in to cross-examine my client. And stuff like that.
Yeah, there's ways to do this. Yeah, you are letting her go up against a person who's trying to kill her for no gain.
Yeah, I mean, maybe he has a plan.
Is this going to go as bad as I think it will go?
I haven't seen this part.
I'm not going to tell you. I can't tell you.
Okay.
Let's find out. Let's find out. Let's go.
I heard this is happening, and I could not watch it.
Sarah!
Yes, sir. Hey, the deputy's got to move her.
I call Sarah to the stand. Good Lord, can't you unchain the poor girl?
Formality of having to move her to the witness stand instead of testifying from the table.
Intentional.
Oh yeah.
Ma'am, you've already been sworn. Counselor, you may proceed.
This is great.
And would you please state your full name?
Sarah Boone.
So you're going to have to speak up or move the mic.
Sarah Boone.
I can't move the mic, sir.
Yes.
Where are you currently housed?
At the Orange County Corrections Department.
Have you been there since February the 25th of 2020?
Correct.
Was that the date of this interrogation that we're here for on this motion?
Yes.
All right. Let me take you back to the morning of finding Jorge Torres in the suitcase.
No emotion.
You called 911?
Yes.
That's probably good.
Is it true that Detective or Deputy Kayla Rodriguez of the Sheriff's Department arrived?
Yes.
She doesn't need me.
What mental state did you have at that time?
Very confused. was very hazy. I didn't understand the monumental amount of people that were there and what they were doing with taking things from my home. I was worried about my dogs. I was worried about my son. I was in shock. I was traumatized by the situation, and then trying to focus on everything that was going on at my home. I was hungover. I was still, I believe, intoxicated to a degree.
Objection, Judge. Move to strike. This is outside their motion to suppress. They have not made any allegations that her statement was involuntary because of her mental state or state of intoxication.
Response?
Judge, we're talking about, I'm just getting some preliminary information.
But
Her interrogation is the next day.
the state has an obligation, and the case law cited by the state requires specificity in the motions. So it's not a game of 20 questions and a surprise.
Okay, this is the day before the interrogation.
I understand that.
We're not talking about an
So are
intoxication.
you going to be arguing anything in conclusion as to what happened on February 24th led to any coercive or coercion behavior on behalf of the Orange County Sheriff's Office on February 25? Are you going to bootstrap or link any of those things together?
The interrogation in the squad car and what was said to her prior to getting in the squad car that relates to what she said about it being routine protocol, yes.
I'm going to sustain the state's objection.
Relating to the intoxication?
Yes. It wasn't raised in any of the 3 motions that have been filed.
Judge, I didn't ask her that. She volunteered
I
to.
understand it. Okay. Objection sustained. Ordinance stricken.
Did you speak to the deputy about what had happened?
Yes,
Okay. And then, were you asked to stay on scene?
by both, yes. By both detectives, yes.
Okay, how long did it take the detectives to arrive after you had spoken initially with Deputy Rodriguez?
It was not right away. I don't know specifically, but it was not quickly.
Okay. Did the the 2 detectives, when they arrived, did they take over the investigation?
It was my understanding, yes.
No foundation for her to move in.
Sustained.
At some point, were the detectives directing you what to do and where to go?
Yes.
Okay. Can you explain what the detectives told you as it relates to you getting in the car? Was the phone issue before the car?
Yes.
Sustained.
Let me ask you about the phone. When were you first asked about your phone?
From my remembering, it was once they arrived, one of the first questions that Hopesall asked me was if I owned a phone.
And what did you tell her?
I told her it was on the kitchen counter.
I said no.
All right. And what happened next as it relates to the phone?
I believe that it was brought to her with someone else. I don't remember.
I'll be right back.
Sustained.
What was the next thing that you were told or talked to about as it relates to the phone?
Unlock it.
Who told you that?
Detective Hopesall.
How did you unlock it?
She handed it to me and I unlocked it.
How do you unlock your phone?
It was with a passcode.
Okay. And when you unlocked it, did you give it back to the detective?
I did.
All right. Did you ever see the phone again?
I did not.
Okay. After that incident, was the next time you were spoken to by Detective Hopesall was in relation to the interview in the squad car?
Yes, she told me I needed to go with her and Detective Lowen to her unmarked vehicle.
And did she tell you anything about what was going to take place once y'all got inside the vehicle?
That she was just going to be asking me general questions.
All right. Was there ever any mention about normal protocol?
Not that I can recall.
Okay. What about once you got in the squad car?
I don't recall the squad car.
Okay. And that was recorded for the court to consider. And so she read you your Miranda rights?
Yes.
All right. Did you answer the questions?
I did.
Did they ever indicate to you that you were a suspect?
No.
Did they ever indicate to you that you were a person of interest?
No.
Did they ever
Not
refer
required.
to the videos that you recorded on your phone from the night before?
No.
Were you ever questioned about those videos at the scene?
I was not.
All right, after they finished interviewing you in the unmarked vehicle, were you allowed to get out?
Yes.
Were you allowed to leave the scene at that point?
I was instructed by both to not.
Okay. And how long did you stay on the scene?
The entire time.
How long was that? How long did it take before the investigation was completed?
10 hours or more.
Okay. At some point, did they all leave?
Yes.
And at some point, did they tell you they were finished with their work there at the scene?
Yes.
Okay. What did you do?
I went inside my apartment and gathered a few things, and then I went to my former husband's residence where my son was located.
All right, and how far was that away?
About 5 minutes.
How did you get there?
I drove.
Okay. What was the reason that you wanted to stay over there the night?
because I was terrified of his family.
Now, later that evening, you were going to spend the night there with your son and with your ex-husband?
Correct.
And did you do that?
My son, yes.
All right. Later that evening, did you attempt to contact Detective Kopsel?
I did.
And whose phone did you use?
Former husband, Brian Boone.
You said your phone had been seized?
Correct.
And you had consented to that? You signed a form allowing them to take the phone?
Yes.
Have there been any discussion about returning the phone?
Waterfall!
Kopsel told me she or Lowen or both would return back to my apartment to return my phone
And when did they tell you this?
before they left the scene.
And did they tell you they would return your phone where?
To myself at the apartment.
And is that what you understood they were going to do?
Yes.
Was there ever any talk about you coming to the sheriff's department the day of this event?
No.
All right, so later that evening, you borrowed your ex-husband Brian Boone's phone and made a phone call. How did you know Detective Kopsel's private cell number?
She gave it to me before she left the scene.
And did you call her?
I did.
Do you recall about what time you called her?
I believe it was around 9:30 or 10 o'clock.
And that would have been on February the 24th of 2020?
Yes.
All right, can you tell us why you were calling her that night?
Before she left and giving me her personal cell phone number, she told me if I were to recall anything or if I just wanted to talk to her about something regarding.
Did she call her?
So I took that to heart and felt very uneasy about how they left the scene.
People can't stop telling on themselves.
Go ahead.
I know, right?
There's no pending question at this time.
Okay, you were concerned about the case and you wanted to call her.
Yes.
And did you talk to her?
Yes.
What did you say to her?
I told her, in all honesty, that I felt that she was trying to trick me.
Sustained.
She said she was trying to trick her.
Did you have a conversation about your phone?
Yes. I asked her.
Answered.
Oh. You may answer the question, ma'am.
Did you call for a yes or no? She said yes, and now I don't know like what's pending and how projected.
Did y'all have a discussion about your phone?
Yes.
Can you elaborate on that discussion?
She told me that I needed to come down to the sheriff's department because she was pregnant and asked me if I remembered about when I was being pregnant. And it would just be a lot easier for her if I were to arrive at the sheriff's department to pick up my phone.
Was there any
Right,
discussion
Masha.
about you
You
being
went down there to
interrogated at
pick
the
up her
sheriff's department?
phone?
No.
Was your understanding the sole purpose of you going to the sheriff's department the next day was to pick up your phone?
Yes.
And the sole reason for the change in plans from them bringing the phone to you was because Detective Kopsel was pregnant and not feeling well?
Correct.
So the next afternoon, did you drive to the sheriff's department?
I did.
Tell us, when you parked your car, where you went, what happened?
I
It's
parked
easier
my
on
car
direct, though,
and,
beautiful.
Left everything as regular in my car and walked through the front door and went to the window asking who I needed to see, and they, I guess, rang them upstairs, and Detective Lowen came downstairs, and I thought I was supposed to be picking my phone up over a particular window, and he says, no, your phone is upstairs, so we would just like for you to come upstairs, and that's where you can pick up your phone.
All right, and so did he escort you upstairs?
He did,
How did y'all get upstairs?
in an elevator.
And what was he wearing?
I believe he was wearing a red shirt along with his firearm and black pants
His firearm was on his waist?
the entire time, yes.
Okay, so y'all got off the elevator, where did you go from there?
He brought me into a very small room.
That firearm question, by the
and
way, is
they
straight
had
out of
me
a
sit down, and then
US
from there I
Supreme
had
Court
a list
case.
of things that I was going to ask them that I might need to do or that I could do.
Okay, so from the elevator, Detective Lowen escorted you directly into the interview room, and we've got the recording, the audio and the video. You didn't go anywhere else
No.
prior to that time. Was there any discussion that you made outside, any discussion between you and either detective about anything, the phone, questioning, anything before walking into that room?
No.
Okay, so directly off the elevator and walked into the interrogation room.
Correct.
And then we've got the video on that. Now, I've watched the video,
Yes.
correct? And you've seen the motion where I've referred to the question where she asked you to sit down.
Yes.
Do you recall that happening?
Yes.
Did that refresh your memory watching the video?
Yes.
Do you recall her saying that she had received the autopsy?
Yes.
Do you recall her saying, I want to read you your rights again because we have to talk about that, referring to the autopsy?
Yes,
This was prior to you being read your Miranda rights.
correct.
And she also said, we're not done talking about the incident. You recall that?
Yes,
And then she said, we just have to do it.
yes.
How did that make you feel?
Sustained.
Were you trying to comply with the officer's demands?
Overruled.
In every way,
Were you trying to cooperate?
in every way,
Were you polite with him?
very.
Did you feel like you could
And when
leave?
she said that, we just have to do it, you said, just like we did yesterday.
Yes,
And then you said normal protocol.
That was going to be his
Yes.
next question.
Is that what she had said the day before?
what do you mean?
Normal protocol.
Yes,
And she said the same word. You said normal protocol to her.
I was reiterating to her what she had said to me the day before.
So she read the Miranda rights to you,
Except number 9.
except number 9. She read the rights and then she said, do you understand what I've just read to you? And you agreed that you had.
Yes,
But you were not read having these rights in mind. Do you agree to speak to me now?
Overruled.
I was not asked that question.
Is it fair to say that after she read the Miranda rights and after she said, do you understand the rights that I've just read to you, that she read right into the questioning?
She did, correct.
So she never got answered from you. Do you agree to speak to us now?
I was never asked that.
The way that she acted, the things that she said, the fact that they had your phone. Did you get the impression you were not getting your phone back if you didn't answer the questions?
Sustained.
She was in custody?
That's been conceded by the state in their response. There was a custodial interrogation.
Okay, but she wasn't aware of it. She wasn't aware she was in custody.
What does her subjective perception
It
matter?
is her subjective. Wait,
Well,
no, is it? Sean,
Under the
is it
circumstances, it
subjective
would
or
matter.
objective?
And if she didn't feel she was free to leave, that she was in an enclosed space.
I can't pause the stream.
She
Dali,
was
is it Dali here?
She was being questioned by 2 lead detectives, homicide detectives. One of them was wearing a firearm. She was trying to cooperate as best she could. I think her
Dali, be back in a sec.
position is that she was coerced in
Ellie went
answering
off
the
to
question.
go.
What does that have to do with coercion? Those
He's
are all
only 5
factors
hours
that
away
under
from Hannah.
Ramirez
He's
as to
already
whether or
in the
not
car.
it was custodial.
He's
Well,
sending a
I
care
know
package
some of the
to her.
factors are whether or not the interrogation actually happens in a
Do
police station, or
$100 a
not, or
quarter.
whether it happens outside a police station. So
There
just
he is.
that environment
come
alone.
back?
That goes to whether or not it was a custodial interrogation. That I'm struggling with the connection
think
on
I
that
can
being
take over the,
non-compliance with Miranda,
thing.
coercion, or the third ground of voluntariness.
Well, and I think it goes subjectively to her and what she was feeling, if she had free choice or not, based on
Subjectivity matter.
excuse me, based on
Subjectivity matter under the case law.
based on the circumstances that she was dealing with at the time, whether or not she felt
So if
she had a
objective
choice.
is-
But what does her subjectivity have to do with that?
Yeah, it's not subjective.
I believe it's relevant.
Objection's overruled. I'm sorry, the objection's sustained. I apologize.
Sorry, your objective
Did you understand you were not going to get your phone back until you answered their questions?
Sustained.
Did you have some questions for them at the end?
I did.
Did you feel like you had a choice in answering their
This
questions?
Sustained.
This judge has already made this decision. Putting
Yeah,
her on the
clearly.
stand is
And
wrong.
that day,
She doesn't come across very sympathetic. So maybe you play this back for her. Be like, look at you. Look at you.
That's actually true.
But I think she knows this isn't like her time. This isn't the Star is Born moment.
No.
Yeah,
I
but
think she
still.
knows that. Well, yeah. Well, she comes off as naturally a bit of a bitch. I mean, there's no way around
She's
that.
got resting bitch face. Look at her right there.
Well, also with her haircut. I mean,
She does kind of have a Nazi
she's got an Eva
mistress.
Braun look going.
Yeah,
Yeah, she looks like Irma Greased.
yeah.
I feel bad for her. Like she
Eva Braun?
used to be quite cute. Like, and
Irma
she's been
Greased.
she's been in jail for 4.5 years.
Yeah.
She just wants a bit of a haircut and some makeup. That's so difficult to get. Women are judged on their looks.
So Rachel's asking about custodial interrogations. Okay, guys. So think
Yeah.
about it like this. Miranda, for it to apply, it's a math equation. You have to have a custodial interrogation, meaning you have to have custody. Okay, well, what's custody mean? Generally, you're not free to go.
Yeah.
Okay, well, obviously, if you're in handcuffs, that's custody. If you're in the back of a police car, that's custody. If you're in the police station, could that be custody? Yeah, that would help. But if the officer says you're free to go, you're obviously not in custody. If you're hanging out on your front porch talking to the cops, you're not in custody. But remember, there's variations. There's a million different ways you could take these elements and put them together.
Yeah. There's if you watch some of the auditors, and I don't recommend you follow their lead, but if you watch some of them, one of the things that they always say is, am I being detained?
Yeah.
The reason why they ask that, well, if I'm not being detained, then I'm free to leave and I'm not answering any of your questions and whatever, you know.
But and then you'll hear the officer every once in a while, no, you're not free to go. I'm like, so I am being detained.
Yeah.
And then the second part is interrogation. Interrogation's there's a bunch of things to that, but it's a lot more basic. Interrogation is any question that's meant to elicit a response in regard to the criminal offense or seeking incrimination from that suspect. So if you're in custody, but the officer says, like, hey, do you need to use the bathroom? You can't go, aha, Miranda violation. No. But also in the same vein, I want a lawyer. I'm not answering any questions. You can't say, hey, officer, can I use the bathroom? They can't go, well, you said we can't talk to you. They can't do that either.
Yeah.
There are limits.
Really do a stream.
There's a case where that happened. I know.
I wonder if you could get like some body cam of a certain YouTuber and then do a breakdown of a custodial interrogation.
Yes.
A certain YouTuber.
Well, I'm hoping we can find it. We got to get it released. Yeah. But anyways, chat, like there's actually a case where that happened where the guy was like, I really got to go to the bathroom. Can you take me to the bathroom? The cop's like, well, so we can't talk to you. Sorry.
Really?
Yeah. Yeah. And then the court's like, come on now.
Oh,
and they're like, because they said we can only talk to you if you waive your rights.
You know what? The other thing was, I saw it earlier in chat. I don't remember who posted it, and they said,
well, that's a shame. I'm going to get to that. So the other thing is comments that will elicit a response.
Yeah.
So there's a famous case where the police arrested a guy, and he had a gun, and he threw the gun away. And the cops are up in the front seat. They're driving along, and Officer Bob and Officer Frank.
His rights.
Yes, he's already said, I want to remain silent. And they say, hey, Bob, we couldn't find that gun. And Frank's like, yeah, man, it'd be a shame if some kid found it and accidentally shot himself or someone else. And the guy's like, oh, my God, no. I'll tell you where I put it. That is.
You voluntarily waived your.
Yeah. Well, he was. They made a comment making him and intending him to violate or revoke his Miranda rights.
Yeah.
So that was considered a Miranda violation. But there's also times where there's another one involving a gun. It's called Quarles v. New York. And the other one's Enos versus Rhode Island. And you guys are like, how the fuck? I remember a lot of these. Quarles v. New York, the guy was like robbing. He was the cops were chasing the guy. And he had his gun. And they arrested him in the grocery store. And the gun skittered away. And it turns out he had shoved it off to the side. And they're like, where's the gun? Where's the gun? Where's the gun? And he's like, it's right over there. And obviously he's in custody. And they're like, where's the gun? Okay, well, part of robbery is having a weapon. The Supreme Court said that was a public safety issue. Like, we didn't want just a live gun out in the middle of the supermarket. Kind of bullshit, but that's what the Supreme Court said. So there are times and ways around Miranda. It's the general idea is, though, custody plus interrogation gives you Miranda. It's a math formula.
Someone had mentioned Jennifer Crumbly during her police interrogation where she said, I think maybe we should get a lawyer. And they kept questioning her.
Yeah.
Yes.
And the reason is because she didn't affirmatively invoke her right. I want a lawyer. That's what you need to say. Well, maybe I need a lawyer. Do you think I need a lawyer? I might need a lawyer. I think I'm.
I need a lawyer dog.
None of that matters.
Oh God, I hate
Get me a lawyer dog.
I hate that one. I hate that one so goddamn much.
You want a lawyer dog? Yeah. No, I want a lawyer. That's what you need to say. Affirmative.
I hope that judge came home to some black dude pounding his wife out like that, because the absolute racism dripping out of that opinion, which I don't generally think that's an issue, but they're like, well, we don't know. No. Maybe you want a dog who passed the bar. It's like, oh, fuck you.
Yeah.
Fuck
that
you.
That was so obvious.
And I hope the judge saw me when I made that comment, that they are whatever they were in Louisiana were a bunch of dickless pussies.
He was, it was upheld on appeal.
Yes, the Louisiana Supreme Court said this is okay because courts don't want to let a bad man walk. He was dead to rights for murder, but they wouldn't let him walk because he was a muddo. He's a bad man.
He's a bad man.
They cucked their way through the Constitution.
Yeah, that really was bullshit.
Counting on government agents to act benevolently is never a good plan.
Can I just say this is an absolute waste of time?
Sorry.
This is 100% on the attorney. This is not on Boone. She doesn't have a right to testify in this stage, and this is.
And she can refuse to testify at this point. He can't force her.
Yep.
No, I think she probably said, please let me go.
Oh, I'm sure. I wouldn't
She
surprise
doesn't know
me
what the
if
fuck she's doing.
Anyways, sorry, Rachel, if you're out there.
Rachel.
Sorry,
Rachel's
I hope
here.
that answers. So it's interpretation of each situation. Yes, and that when you like the Fourth and Fifth Amendment issues there, searches become that way too. But yeah, Fifth Amendment right to silence, and then there's Sixth Amendment right to silence. And you're like, wait, there isn't right to silence in the Sixth Amendment. There actually is. The way the Supreme Court's looked at it. Yes, it's very fact specific.
Yeah.
Like there's a case that it all depends. It all depends.
Yeah.
So
we're gonna try my stream again. See if
Sorry,
my Aussie
guys.
internet's working.
That was a lot of talking. I'm so sorry.
That's all right. No,
Did
it's
you
good.
know that you were going to be placed in custody?
I did not.
Did you know that you were going to be arrested?
I did not.
Did you know that you were going to be questioned?
I find that hard to believe.
Were you trying to cooperate with law enforcement based on?
Yep. Damn Aussie internet.
I did not.
Did you know that you were going to be questioned?
I did not.
No, it's actually just
Were you
my
trying
connection.
to cooperate with law enforcement
Chinese,
based on
Ella.
her statements that you have to talk to us?
Yes.
Were you there answering her questions because she confirmed that this was normal protocol?
That was my understanding, yes.
That's all the questions I have.
Any cross-examination?
So that afternoon on February 24th of 2020, when Deputy
This is buckle up, chat. This is why you don't talk.
What was the question? What was the question?
You can rewind it, but this. Oh God.
Yeah.
Oh, this makes me think about this part.
Any cross-examination?
Let's cross. Oh, yeah, okay.
So that afternoon on February 24th of 2020, when Deputy Kayla Rodriguez arrived at your residence shortly after 1 p.m., you were under the influence of alcohol, correct?
Yes.
You were impaired by alcohol, correct?
I don't know as much as impaired means. It did affect, yes.
Okay. And that was consumption from the night before, correct?
Yes.
So you did not go to brunch that morning and have mimosas or anything else to drink, correct? And you consumed no alcohol in your home that morning, correct?
Correct.
So does that affect in any way your memory when you testify about the events that transpired between you and Detective Copesel that afternoon?
Ask one more time, please.
Did alcohol have any effect on your memory of what happened between you and Detective Copesel that afternoon?
Now or then?
Then?
Did alcohol affect my conversation with her?
There's a jury instruction that says a witness's memory and perception is pertinent. And I'm asking you, did the alcohol that you were under the influence of affect your memory or perception of the events that you've testified to today that you said happened on that afternoon of February 24th, 2020?
So did they affect?
He should
My
be
answer?
objecting right now, screaming objections like his hair is on fire.
I don't. It's been asked 3 different ways.
So we'll leave it at you were under the influence of alcohol that afternoon, correct?
Objection.
I think she said she doesn't know what. She said that she had alcohol under the influence or impaired.
The objection is, the court does not entertain speaking objections. The legal grounds need to be provided. What are the legal grounds of your objection?
It's speculation. She doesn't know the answer.
She said she didn't know what.
What are the legal grounds of your objection?
Speculation.
All right, you may proceed.
And you understand that you're
I
charged with
don't
second-degree
know.
murder in this case, correct?
Yeah, she
You're
said
facing
she
a
didn't know that
penalty of life in prison,
speculation.
correct? Do you understand that the score sheet minimum is probably about 22 and a half years?
Object.
I don't know.
Okay.
Why is that relevant?
And
Object.
it is your desire to have these statements excluded from the jury's consideration, correct?
Object.
I'll object to that.
Sustain the objection. Go ahead.
Your intent is to testify differently than you have testified in the
Objection.
State's Exhibit 1, correct?
Objection.
regarding the.
I would object to that. I'm not understanding the question.
Mr. J.
Judge, a witness's bias is always at issue when they take the stand, and it's our position that her credibility for all the things that she has testified to today, that particularly the things in conflict with Detective Kopsel's testimony, and the court, of course, in a motion to suppress, has to consider the credibility of the witnesses, and you are in the best position to do that. The appellate court, they're going to be very deferential to you. It's our position that she's biased. She is charged with second-degree murder. She's facing life in prison. Based on the examination that both state attorneys and defense counsel and the state's expert witness today, it is the state's belief that she is intending to testify differently than she testified in the statements that she provided to law enforcement in State's Exhibit 1, and therefore she is biased in all the things that she's testified about today because it's her intent to get this statement.
Yeah, assumes facts, not in evidence,
it's all speculative. Yes, those statements aren't sworn statements.
No.
Yeah.
So she can offer, it's not different testimony.
It assumes facts. It assumes facts, not in evidence. The testimony at trial, whether she testifies or not, none of this has happened.
Yeah. So if she doesn't testify at trial, is he just going to throw his hands up and go, "Oh shucks"?
Well, God, we got to redo this hearing.
Yeah.
This is like you can't. This is basically what's been going on in like chats all over YouTube. People are going, "Oh, she's going to say this. Oh, she thinks that."
Well, yeah, no, she is going to. We know what she's going to try to do.
Yeah, but still, it hasn't happened yet.
Yes, it hasn't happened yet.
It hasn't happened.
I agree.
Exactly. The prosecutor can't say that.
Yes, he's basically saying, "Judge, we know what's going to happen, like we all do." And it's like, okay, you may be right, but you have to wait till it happens.
Yeah, he's being a wine mom.
I jump the gun a lot.
He's like, it's wine mom testimony or wine mom argument, basically.
Oh.
That doesn't hold up.
Judge, we know she's guilty.
Oh, we know she's guilty. Why are we even bothering?
That's pretty much what he's saying.
Yeah. Lawyers are mad. He's big mad.
The statements or the statement on 225 thrown out so that she is not going to be cross-examined and impeached with it so that she can testify the way that she testified this afternoon.
Response.
Judge, I agree with the impeachment about being under influence. I agree with the impeachment about what she's facing.
Why would you agree to that?
She may be biased because she's facing life in prison. He claims 22 years.
Never fucking agree.
I agree with all that. We just got through at the jail. Meeting the state's expert who evaluated Sarah Boone. I was present. The two prosecutors were present. It wasn't recorded.
The hell is he going with this?
He can't be a witness now.
Judge,
if he's going to question her
assumes
about
facts,
what was
not in
said
evidence. She
during
hasn't
that
testified at trial yet.
He's putting himself potentially to be a witness down the road. I don't think that's proper cross-examination about what she said there versus what she's saying here.
Anything further? Mr. J.
I am not specifically asking her what she said that was different. And obviously, if I did and she testified differently, I would have to accept that answer. There's no way for me to extrinsically impeach her with that due to the brevity of the time frame that we have always objected to. But I do believe it's a fair question to ask her whether or not she intends to testify differently than her statements that are in State's Exhibit 1 and consistently with how she testified.
Okay, so first of all, I would object to trial strategy work product. We don't even know if she's going to testify yet.
Yeah.
And that gets into trial strategy. Is she going to testify differently? Assumes facts, not in evidence, because and it calls for speculation. There's so many reasons to preclude this question.
And he's not objecting to him at all.
Well, not in the right way. He's rambling on about food in the jail or something. I don't know.
Yeah.
This is a shame.
This afternoon.
He's been doing good up till now.
Unless she understands.
Yeah.
Yeah, but see, this is really bad. So he's doing really good, except for the part he's really fucking up.
Yeah, when you do okay most of the way, and then you really fuck up, you just really fucked up at the
Okay,
end.
but
yeah, like he did a really good job. He crashed on a final approach. It's like, well,
but let's just say Sarah's like, I need to testify, and he's like, no, this is going to be an S show, and Sarah's like, no, I'm going to testify.
I want that written down.
Yeah, I want it written down, and I want her knowing.
Or on the record saying she wants to. I recommended she doesn't.
Yeah. Would you then give her? I mean, it could hurt her a little bit, but it's better than the main event.
You're talking about now? She has no right to testify now.
No, I know that, but like, could he have been like, okay, well, this is I think it's going to be a bad idea, but why don't we go ahead and have you testify here at this hearing to give you the experience and for you to really appreciate the gravity of what the prosecutor is going to do.
I mean, It's a bad idea. It's a bad idea.
Okay.
But, you know, sometimes you do have hard-headed clients that need to learn the hard way, and this, I guess, is the safest way to learn the hard way.
That's what I'm saying.
But
maybe. But it also almost verges on malpractice.
Yeah, it kind of
Okay.
does.
All right.
Okay.
I was just trying to think of like a, explanation, but
Because,
Never a
you know,
good
it
thing
doesn't
to
take much for Sarah
self-incriminate.
to all of a sudden say, I want to go my
Yeah.
own way, Judge, which, like, I was waiting for this to happen.
Mm.
Next
Hands
week,
would
we're
benefit
going to
her
have
if
a
these
hearing
statements were
on her
excluded.
motion to fire her attorney.
Look, she's. I don't think she's actually ever fired any attorney. But the thing is that she will testify. We all know she's just going to do what she wants to do. She's going to testify, no question. Like, and he said it. He said it a few times now in open court that she's going to testify, and
Which is
he's saying so.
dangerous.
a bad idea. Even
Yeah, he's not
saying
going to be able
it
to talk her out of it.
You never promise that. You never
even
promise-
saying it in opening is a bad idea.
No, you never promise it because let's say she doesn't. Well, now you lied.
Yeah. I mean, even if you're sure she will,
Doesn't
there's just
I don't care if it's Kyle Rittenhouse.
yeah.
I don't care what type of strategy it is. I don't promise you. I have no obligation to promise a jury
No.
anything.
And you can always catch the prosecution off guard.
Yeah.
But is that considered lying because you're not responsible for her?
The jury's
It's her
going to
right.
see it as lying because you promised something in opening statements and then you weren't able to deliver.
Yeah, or
Jury's
they'll
gonna be
say,
like,
"Oh, she
we were
didn't
waiting
testify
for
'cause she's
Sarah to
guilty."
testify. Oh
Yeah.
my God, Sarah's going to testify? All right, well, we're going to sit back and wait for that. And then she never does. We were like, we were promised Sarah.
Yeah,
that was a
you
lie.
We were promised the main event.
You lied, and then here's the thing, Hella.
Yeah.
You lied as an attorney, and also she's probably guilty.
Yeah.
Yeah.
Okay. I see. Yep.
Yeah.
Yeah, this is.
You can
Remember,
hold
it's
it against
sales.
her.
You don't want to buy a car from the guy who's lying to you.
Yeah.
That's fair.
At the end of the day, yeah, it is just who's the best salesman.
That's fair. You're not supposed to hold it against her, but if the lawyer has
Speaking of
said,
Salvador, I got a car to sell you.
Oh God.
of course, she's going to.
So I'm going to sustain the objection based on how the question was asked. I'll allow you to revisit it based on how you just explained it to me.
You gave statements
yeah, I
to
saw
an
that.
evaluator this afternoon, did you not?
I did.
All right. And without going into the details, would you agree that there are some differences in those statements as to what is in the statements you provided to law enforcement on February 25th of 2020?
Yes.
And you understand that I would be able to cross-examine you on giving inconsistent statements at trial if you take the stand, correct?
I understand.
And so you understand the benefit of this motion to suppress being granted.
Of course.
No other questions?
Any redirect examination?
All that's
Okay.
usable against her
we can
at
have Ms. Boone
trial.
return
That
back to counsel's
entire
table
bit of testimony.
while she's in the process.
Well, only if she testifies, right?
I would argue yes, because but I could see them still trying to throw it out there.
Yeah, because
Okay.
they don't have a witness otherwise, so they would only be able to do
I
it
mean,
with
the
her.
janitor in the courtroom, but
No, because he wouldn't be. But here's
Yeah.
the thing: they are going to burn her down with this.
yeah, if she
Yeah.
testifies, and yeah,
You admitted you were going to tell a different story, didn't you? Yes. No, you didn't.
No.
Really? So you didn't say this? They could play the tape.
oh yeah,
Also, returning to counsel's table. Anything else further from an
No
evidence or testimony
positives to
perspective from
this.
your side of the ledger? Okay. Anything
you're
else
right.
from the state?
Nothing
other than
was
argument?
gained from
Just
this,
argument. Okay.
unless
All right. Once Ms. Boone
just a
seated, we proceed
weird
with any argument.
calculated attempt to scare
And as the
her
court
out of
identified previously, I
testifying.
have reviewed.
or maybe you're trying to trick the prosecutor into opening the door somehow. I don't know what.
No,
but-
because this judge ain't going to let you run wild.
oh, that's true.
Judge Kranick, he's
Yeah.
very much on the,
State side.
He's going to have this if the courtroom catches on fire. He's going to scream at people, sit
Oh, yeah.
your fucking ass down. We're finishing this trial.
Oh yeah, I reckon he's got a trip to
Guarantee you.
Bangkok planned.
Yeah,
Guaranteed
What are
he
you
will not
implying
let
there,
people.
What am I implying?
Thailand maybe.
Yeah, Thailand is Bangkok.
Oh, okay,
Yeah,
gotcha.
you
Whatever.
know what I mean.
Salvador's
You
a
know
world
what I mean.
traveler. Can you tell?
Yeah.
He's got a trip planned. He's got some.
Oh, yes,
friends
authorities
there.
that were provided. Mr. Owens,
So,
your motion,
is this-
sir, you may proceed.
Is this argument going to be brilliant, or rehashing the same old stuff?
Is this to do with the hair and makeup?
We got Tyra Banks to testify here.
Judge, my understanding of the law regarding Miranda,
Is wrong.
first issue is, was the defendant in custody, was the suspect in custody? Was it a custodial interrogation? We have agreed or stipulated to that fact. We're referring to the 2-hour interrogation at the Orange County Sheriff's Department. Specifically, we're referring to about the first minute or two
Oh, wow.
of that video.
Oh, we got a cat raid.
I don't
Cat raid.
As in cats.
Catnut Williams has rated us.
Oh,
Nice.
Thank you so
Hello,
much, Cat.
everybody.
Thanks, cat.
You are great.
Lovely.
And thank you for the gift and memberships earlier. We are
appreciate it.
watching the Sarah Boone trial, and got Boone.
Yes. It's not the trial, it's the
Or, sorry, hearing.
last pre-trial hearing. The trial starts
Jury's
next
returning a
week.
verdict in 2 minutes.
Yeah. The trial starts next week. So, guys, if you don't know about this, she allegedly put her boyfriend into a suitcase, hence us being in a suitcase.
Yes.
And, yes, we have with us special guests today. We have Mr. Potentially Criminal up in the top right-hand corner. And we have Mr. Making Law Simple there in just underneath him. And we have Mr. Dali Talk below me. Hello, everybody. Meow, says Cat. Hello, Cat. Good to see you.
He's ridiculous.
You were here earlier.
Hello, Cat.
Hey.
What is this attorney going to argue, though, that he hasn't already argued? He already he started off with, well, my understanding of Miranda, which is completely wrong, and the judge has told him he's wrong several times. He's making, at this point, I would just say, Judge, I'm going to rely on my written briefs and my other arguments and sit down. I don't know why he would stand up here for another 20 minutes.
Because he's got no other option. Like, he knows this is a toast thing.
Yeah,
You
but you
gotta
can
try.
still find your way out. Just be like, Judge, I rely on my written pleadings and the evidence before you.
Yeah.
No, I agree, but
So basically, what the biggest argument of the day has been the motion to suppress the 2-hour and a bit interrogation of Miss Sarah Boone, big time incriminating herself and saying, ooh, this.
Not intentional.
Yes, which is pretty bad considering that she's going now for a self-defense argument
Yes.
of battered spouse syndrome.
And really.
Sarah Boone
Sean, how do you think that's going to go?
Yeah, she really does need a lawyer. Yeah. Yes, guys, actually, we haven't really spoken about that before we finish the hearing. Should we? And we have some new people here. What do you guys think about the whole battered spouse syndrome thing?
Well, it's never really been recognized as a legitimate defense. At most, it's been a mitigating factor for sentencing.
Sure.
They're still pushing it, and they're trying to get it to this like elevated sense. And just by so for comparison, they have this. Sean, you and I were talking about it earlier with the Kentucky guy. I keep losing the term.
heat of the moment. So it's like manslaughter.
Heat of passion, heat of moment, which can reduce your conviction from, say, like a first degree, even though you intentionally shot him. Because of this emotion going on, this heat of passion situation, you can reduce it down to, say, like a manslaughter or a second degree.
And that's in Ohio, battered spouse has done that before.
Has it?
A lot of people to get manslaughter, yeah.
So that's one of the few occasions where I've actually heard of it working, because it doesn't work in Michigan. They've tried for years. But that's the idea behind it. It's like sort of this emotional state that you're in. And it doesn't get you off the hook, but it lessens your guilt. Where it's been used in Michigan is really with sentencing. So it's kind of I'm guilty, but let me explain sort of situation. And but that's what it is. She's trying to get down to this battered spouse, but the battered spouse isn't going to get her off the hook. It's just going to get her from second degree to like manslaughter.
Well, I think that's
that would
just
be incredible, though. That would be goddamn incredible to get down to manslaughter. Sorry, go on, Sean.
I'm surprised she hasn't been offered a manslaughter.
I bet she has.
There was Owens originally came on to help her with plea negotiations, and he never said what they tried to give her, but she did not take it.
See, in Michigan, we have status conferences and the judge puts on the record, was an offer made? What was the offer? Was the offer accepted? No. Okay, we move forward. And that's on the record. They don't have that apparently in this.
I would hope they'd put like last best plea on the record for sentencing.
A lot of times, I bet we'll start off at some point right before the trial starts with what was the last best offer.
I mean, they do
just so
normally
she
put
can
that.
say, because the way we do it, the way a lot of judges here in Ohio do it, they'll do that because then they'll even explain to the defendant that way you can't jerk us around in 5 years and say, "Well, I didn't know what the offer was."
That's why we do it. We do it every settlement or every like status conference.
Well, we do it every settlement, but there's a couple of judges I've been in front of where like right before trial starts, like, "All right, knucklehead, you understand this," and then it takes care of that.
Yeah.
So that's the thing. Like, she's facing second-degree murder, which I suppose is a life sentence, and at a maximum. But at the moment, she's served nearly 5 years. If she were to manage to get a lesser included charge like manslaughter, based on the battered spouse syndrome defense, she could be looking at nearly time served, like only a few years more maybe until she gets out. She'll get like, I don't know. She could get like 25 years, I think.
For manslaughter?
For manslaughter.
22 to life.
For second degree.
That's second degree,
for second
manslaughter, it's not much. Let me look it up again.
I mean, yes, it's highly unlikely, Maddie B. But if
up to 15
Owens,
years in prison.
Up to 15, okay.
If Owens manages to get that, I reckon that is like a Spiro kind of move. Like, if he comes in from out of nowhere with 3 weeks, 4 weeks to prepare and gets her out of prison in like a couple of years, I reckon that is just a Superman move from his perspective.
I think Boone has burned all the bridges and rubbed everybody the wrong way. I doubt very much the prosecutors are going to make her any sort of really decent plea at this point.
No, he would have to convince a jury.
Well, yeah, but
I mean, you could get the jury to split the baby.
People.
Yeah,
could,
no,
I mean,
well, I was going to say, here's the thing. On much of the same vein, David, the judge is going to be like, "Well, we're agreeing to 5 years." Like, okay, fine. Here's 10. Get lost. Like, I don't think the judge is very much.
No, judge is going to say F you.
Is this a judge taking it to trial?
Yeah.
Okay. Because I know that she was switching judges for a while. So
this is the
this
new
is
judge. Yeah.
This is the new judge. Yeah.
Yeah. He's not a fan.
No. Can you tell?
Say though, David, did you see Fred Bankowitz gave an interview?
No, I didn't.
He did.
Oh,
I think he should be.
I did a review of that yesterday.
I was very pissed off watching that.
Oh yeah.
I watched it myself privately, and he talks about a lot of the like internal things going on, and I'm like,
yeah,
you need to
so
shut.
It was bad.
Shut the fuck up.
Excited. You did it? You covered it?
I did. I covered it. I covered it 2 days ago, and I also showed her letters about him and to him at the time. I remember, David, you covering Bankowitz. He did all work in the 14 months that he represented her. He went missing for 5 months at a time. He went missing for 5 months. He gave no phone numbers that worked, right? Like,
those trips with Salvador to Bangkok, they take some time.
He was absolutely the most incompetent, and for him to now go on court TV just after he secured his $15,000 from the JAC.
Did they all get their 15?
Yes, they all got their $15,000.
Righteous bucks.
They deserve it.
Right? Look, they deserve it, but she hasn't been to trial yet. And here he is going on court TV and commenting on this motion to suppress.
Yeah.
Right?
No, I agree. You should not be commenting on your client's cases like that, especially while they're active. And even if it's over.
I may have called out a few people live on one of my streams about commenting nationwide, broadcasting out there, commenting about ongoing cases that you're actively involved in. It's not a good idea.
I think there's no comment.
Unbelievable. Well, if one of the mods, please, one of you guys,
I would never do
mind
that
putting
shit.
that stream of mine into chat, that would be great. Because I put a fair bit of research and thought into that. I don't usually go after lawyers. I don't like doing it, especially defense lawyers. But Bankowitz, seriously, that was a garbage
disgusting.
move. That was a
That was
garbage
disgusting
move.
interview.
I'm gonna watch
Yeah.
it. I see it here. I got it up.
It was bad.
I kind of want, like, he needs to get there needs to be a. I don't necessarily want to see the man disbarred, but he needs to be like,
Slapped
listen,
around.
guys, don't go.
He needs a phone call. I tell you what, like,
You're the one that I thought had a good rapport with Boone and was getting.
no,
on.
that was Hobson.
No, that
Oh,
yeah,
that's
it's a
okay, yeah, yeah.
Blackwood
Hobson.
guy.
Yeah, Hobson. Yep.
Yeah.
Hobson was only there
I
for a
don't
few
see
months.
right, Salvador.
Bankowitz was there for 14 months, and in the 14-month period, there was a 5-month period when he was uncontactable, and then another 100 days.
Yeah, that was the one where
Yeah.
Sarah was doing the whole.
That's her
whole,
furious letter writing campaign.
Yeah, that was
Yeah.
her Seasons of Love phase where she was
Well,
counting
in her
out
defense,
seconds
she had to
and
use her investigator to contact her lawyer.
She tried everything to try and contact this guy.
Yeah.
Yeah. And, oh my God, is that another 10 memberships from Dina? Is that twice now in this stream? Dina, oh my God, you're amazing. And so that's 10 more, and we are 15 away from another thing on the screen. I love you, Dina. You're amazing. Thank you so much. I tell you what, she's just so great. One of my best friends. And, Dina, why are there only 50 likes if there's over 200 people here? Also, there's over 200 people here. Awesome. And that's very much thanks to my guests, and thank you to Katnott Williams for the rate. I really appreciate it. Guys, from 6 p.m. Eastern, every night of the trial, fast mode, and we'll be watching the trial in catch up, so you don't have to be waiting around for lunch breaks and things like that. I think, Sean, are you going to be running it during the day?
I'm going to try to when I can, yes.
Yes, awesome. So if you want to be watching it live, that would be the place to be watching it. I don't think David's going to be playing it. He's going to be over here with us at night times.
Yeah,
So-
I'm not streaming it. I'll be probably in Sean's chat, and if I can make it work, I'll be over here on panel to comment and criticize.
Lovely. Thank you for the super chat as well, Dina. Okay, let's finish this off. Make sure you stick around, guys. There's trivia at the end.
And I think under the totality of the circumstances, the court has to determine whether freely and voluntarily and knowingly given under the circumstances. Judge, law enforcement, after they get a valid waiver of rights, that I'm not going to be silent, that I'm going to answer questions, go ahead, ask me and I'll answer the questions. Once that happens, law enforcement is trying to get a confession. Law enforcement is trying to get admissions that they can later use at trial to impeach the defendant and convict him. The law allows law enforcement at that stage to use deception, to lie, to trick.
Yes, they do. Yep.
We found
Super
another
law, but
weapon.
they do.
It's got your DNA on it.
They're allowed to use
Your
cunning and
co-defendant
deceit.
has come in here and confessed and implicated you. All those techniques, when it's really deception, they don't have the DNA, they don't have the murder weapon, they don't have the co-defendant, can be utilized to obtain a confession or an admission of guilt. But prior to Miranda, you cannot deceive.
Not
Prior
true at
to
all.
Miranda, you cannot trick.
That's not true at all.
That's what.
That is not true at all.
That's
not
what
true.
That's what the drug dealers always say. Like, are you a cop? You gotta tell me if you're a cop.
Yeah, that's not true. Chat, that is not true at all. That is
So bullshit.
hate to say it, but that is Nick Ricada level legal advice. Do not accept that.
Sarah Boone's already won.
That is not acceptable. That is not that's not true.
That's a burn right here on this channel. Oh, damn. Hi,
I
Cully.
mean, that is
Damn.
it's a Baldo Tech Law School.
Oh,
theory.
well. Oh, well. We
Oh,
can
God.
hope.
Oh God, he's gonna embrace the Baldo after this.
I embrace the ball.
You know, David, if Michigan Tech had a law school, that's the kind of answer they would give.
Yeah, right.
All right, let's keep going.
That right is fundamental.
Ah!
What is the fundamental right?
You
Yes.
cannot be compelled.
Oh, we have 10 more. Thank you, Cat Not Williams.
Oh my
Much
God.
appreciated. That is so
You're
cool.
so sweet. Thank you.
You are so sweet.
Thank you, Kat. Yeah.
Is that 20
Awesome.
this is that 20 this stream? That is so nice of you. That means we're 5 away from another thing on the screen, everybody. 5 away. And you need to all tell me what you think the next thing should be. We have wine. Guys, look, we have wine on the screen in the apartment. We're in the apartment, everyone. We have wine and we have a pen and paper for writing letters. Whatever, if we get 5 more gifted memberships today, another thing will pop up in the
I want
apartment.
to see a trashy romance novel, but
Oh,
I can see that. 50 Shades of Grey.
Yeah.
She likes
5 more
bondage.
gifted memberships, everybody. We'll get there today. Let's keep going. Thank you, Kat.
Rico says a low-tech
To
law
incriminate
school
yourself.
grad. Yeah, trust me, I understand.
You cannot be forced to talk. It's got to be free will and a choice. And so you can't seduce
Put a
or
Dr.
coerce
Pepper on the counter.
someone into giving a statement. And the law is
Yeah,
clear.
Dr. Pepper on
when
the
that
counter
happens,
sounds good.
we've got to punish
2 liter.
law enforcement to correct that type of misuse behavior. It's illegal. So you've got Detective Kopsel on the one hand. I got to read you your rights. And you have a right to remain silent. But within a
anything
minute
you say
before,
can and will be used against you in the court of law.
the detective is telling Sarah Boone, we have to do this.
Alligator in the suit.
We have to talk to you. Now,
I don't like that.
that's confusing.
Is it?
That's deceptive.
They're allowed
There's
to be.
nowhere in policy that that should be allowed or is allowed. There's nowhere in the
Doesn't
law
matter.
that that should be
I'll
allowed.
agree
It's
with it.
actually illegal. To tell a suspect,
illegal?
we have to talk to
not.
you. We just have to.
Is it?
Before reading Miranda rights. That is an illegal statement. Sarah Boone did not have to talk to them about the autopsy.
Not in
Sarah
this
Boone
particular
did not
fact
have to
pattern.
talk further
No.
about what had happened.
Not in this fact pattern. This argument doesn't.
But that's the implication this detective gave Sarah Boone. It taints the Miranda that comes before it. Here's a law enforcement officer. I'm trying to cooperate. We've got to talk to you, but you have a right to remain
So
silent.
this boomer's going to get up, bring up the fact she was pregnant, her hormones were out of balance.
The
caused her to
statement of
lie.
we have to read you the rights was made before we have to talk to you. So your argument transposes those two things chronologically.
Why are we even having it? I mean, why even have the confusion? When we're sitting here Monday morning quarterbacking, but Sarah Boone,
Ooh, thank you, Nancy
Was
Long,
brought
for the
there
one
under
excited
false
utterance
pretenses.
membership. Very nice
a
of
traumatic
you.
event, she
so
lost her
sweet.
boyfriend. I'm coming to get my phone.
Praying the gray away.
I've been tricked into coming up here to get my phone.
Keep moving, Grace.
And I'm sitting here having to figure out
moving.
what to do about whether to talk to these people or not. And she's talking about my rights, but then saying, we have to talk to you. We just need to do it. And then she reads the rights.
Hey, gee.
Right there within
Well
a few seconds of
done.
each other.
Yay.
Nice.
That's improper. It's illegal. It's coercive. It forces this not to be
Hope you didn't
a valid
plagiarize
waiver of her
Mark
rights
Jensen.
under that circumstance, coupled with the fact that she came down under false pretenses. Coupled with the fact she doesn't have the ninth question.
Could have lost the suitcase in
If you
a
think about it, okay, you got a right to remain
accident.
silent, you got a right to a lawyer. Those 3 or 4 questions. and
Jeez,
then,
Dolly.
do you understand what I've just read to you? I'm paraphrasing.
boating accident, whatever.
But
No,
then
I
the
got you. I
text
got
goes
you. It was
right into
good.
question.
That
Once
was
Sarah
good.
says, yes, I understand, it's an acquiesce to authority. Okay, let me start asking her questions. The critical question is, having these rights in mind, do you agree to speak with us? That
Come on, Jack.
is
Here's my
the
legal
time
analysis
of
right
free
now.
choice. That is the time of decision for Sarah,
Yeah,
to be
you're
given that
boring.
opportunity. But the way, I understand, Detective Kopsel had the autopsy. She had the blunt force
Yeah,
trauma.
let's speed him up.
Those were not questions. She was not, Sarah Boone was not questioned
Yeah.
about that. They didn't know about
That
that
was me.
until the medical examiner. So she had additional information that she wanted from Sarah Boone. She had the 2 videos from Sarah Boone's phone. She had additional information on the phone that was inconsistent with a statement that Sarah had given the day before. So sure, any detective worth their salt would want a statement. She'd already said we had probable cause. We'd already made our mind up.
Any
that we were gonna arrest her.
detective worth
They were-
their
If she didn't come, they were
salt.
going to go get her. If she came and said, I want to invoke
Marsha
my
has a
rights,
point.
she was going to be arrested. They wanted to get some type of admission, confession, statement that they could later use, which they're trying to do now. But under the circumstances, the totality of the circumstances about how she was induced to come down there, about telling me she had to talk, Judge, it was coercive. We would ask that you suppress the evidence.
Any response?
Oh, Benjamin.
Judge, the United States Supreme Court has said that confessions are good. They're good for society. It is good when
Thank
guilty
you
people
for
are
being a
convicted.
member for
We
8
stand by all the
months.
case law that we've cited, and you have reviewed the evidence from start to finish. Under the totality of the circumstances of that 2-hour and 6-minute statement that she gave to law enforcement, she knowingly and intelligently and voluntarily waived her Miranda rights. And under the case law, it was done perfectly fine.
Intelligently.
There's no requirement that that question number 9 get read.
Well, let's not
and
get
as far
carried
as any
away.
credibility
Yeah,
issues
that's
that
pushing
are
it.
pertinent to the court's analysis, which the state would submit there is not, because we're conceding there was custody on February 25th. They are allowed to use subterfuge and deception to get somebody to come to the police station under the case law and authority cited. But if
They
there
shouldn't
is
be allowed
anything
to, though.
that is dependent upon the credibility of either the defendant's testimony or Detective Kupsel's testimony, the state would argue for the reasons of her being
See,
impaired
he's
by her own
talking
admission
fast
on
because
afternoon
the other
of
dude was
February
talking
24th,
slow.
Still from the night before. That her credibility is less than Detective Kupsel's, and of course she has a bias and interest in the outcome of the case, whereas Detective Kupsel has no motivation to not tell the truth about whether she used deception to bring the defendant down to the police station, because that's perfectly acceptable.
That's also
so asking
pushing
you for
it.
the reasons that we stated in our multiple responses to their multiple amended motions to deny their motion to suppress. Thank you.
Any further argument, Mr.
Okay, bye.
Owens? All right.
Okay, thanks, bye.
Tomorrow is a court holiday. The court has had the opportunity to review all the case law. Court's going to prepare a written order, and you'll have it before the close of business tomorrow. Courthouse may be closed, but I'll be here. working.
Nice.
But just for the record, there's 2 exhibits that I tried to introduce. They will be admitted to the record.
Yes, of course. They were pre-marked. Moving now
So-
to the defendant's motion for a right to hair, cosmetics, and civilian clothing without restraints for trial.
Darling.
State.
Thanks. Yeah.
What,
so
what's the
he's
court
not.
holiday?
I don't know. What is the court holiday?
Is October 1st a holiday, or tomorrow is the 3rd? Is there a? I mean, it's just generally courts have holidays when there's like.
I don't know.
Is it the holiday of maximum occupancy or what?
Oh, it's Rosh Hashanah.
Oh, it is. Oh, God, you're right. It is
Wachiana?
Rosh Hashanah, the Jewish holy days.
Oh. We don't
Trust
have
me, I
Jewish
remember. I
holidays
had to
here.
learn this in law school because imagine this, there are a bunch of
It's a Jewish
lawyers
holiday,
who were,
right.
little
Black
hats
Road
and they're
Day.
professors. So like,
Okay. Well, I guess they're
You'd
not
miss-
taking
you'd
it off
miss,
tomorrow in
they'd
Israel.
have to cancel class a lot. So
Shauna's
like, we'd have Rosh
raises.
Hashanah off.
I have no court tomorrow, so that's good.
I have court tomorrow, so I'm like,
Hang on, is it just in Florida or is it everywhere?
no. Generally, most courts will, like a lot of places. Like, well, here's the thing: even if it's not like New York City, they're going to close down. But like, if you are in, well, let's be real, it's like New York
Kentucky.
City versus like Wyoming.
Yeah.
That said,
Alabama.
though, if you are if you are Jewish and you write like, look, it's Rosh Hashanah, I can't, like, I need to continue this judge as an attorney. There's no judge out there who's gonna be like, deny, get your ass to court.
Oh, really?
So yeah,
Oh,
YSL's out
no.
there next Wednesday. Well,
Oh, really? Having
Yeah.
a big holiday, are they?
I think that might have been pre-scheduled,
Oh, they might be doing motions or.
or there might be some
Half
disaster
Irish.
issues.
I
with the
remember.
hurricane.
It was Sean that forgot.
Oh, right.
Yes.
Okay. So, Judge is going
I
to take
forgot
till the
what?
end of tomorrow
Holiday.
to write
She,
his order
She
on
says
this.
that Good Logic's going to be mad at us for forgetting. I said, I remember. You forgot.
Yeah.
Yeah, so Judge is going to take till the end of tomorrow to write an order on this. He's not ruling from the bench. He's actually
No,
writing an
and-
order.
well,
No,
he's
because
gonna-
he's going to cite all the law and he's going to make the reason.
He's going to
argument.
copy and paste. Yeah,
He's going to go to Grok.
because he can
Gonna get
easily
the
just
grok.
go denied, and he probably should just say denied. But
Yeah, can
Yeah.
you just get it over with? Like,
Yeah.
really? All right, let's keep going.
What, if
need
any,
to hear
positions
about
do you
her hair
have with
makeup.
regard to the restraints?
Somebody
Again, we've
give me a
already
pager.
decided that issue.
Ah, the
I don't know that
restraints.
there's been any new allegations alleged in the motions by Mr. Owens on behalf of the defendant, but the court has decided that already, and unless there was some sort of change in position or authority, then the court should maintain the law of the case.
Response.
And Judge, I just want clarification, but, she's here today and she's in handcuffs, so she has difficulty writing. She has,
Let me just interject for 1 second. She will be hands-free.
okay.
So the issue is the leg restraints.
And Judge, she's presumed innocent. I understand security has an obligation. There's 3 doors. I assume we're going to be trying the case in this courtroom. There's 3 doors. I know that we've got several security officers here in case she were to try to flee. But she's got no access to weapons or anything of that nature. She has a fundamental right to a fair trial. She has the fundamental right to a presumption of innocence. And if the jury were to see any restraints on her freedom, they're going to automatically assume the worst, that she is a danger. And people automatically would take that to heart, and it will affect their decision when they go back into the jury room. So
I'm going to remember that, Red
No, she agreed to it when she was pro se.
Yeah.
No, and then she fought back on it. And it's like, well, no, I don't want
Well,
it.
no.
And the judge was like, well, your only other option is you to be like chained to the table. And she was like, well, let me weigh my options because I don't know if I want chained to the table, but I don't know if I want the shock.
Okay, but it would be on her leg so she couldn't wear a sexy skirt in front of the jury.
Right. That's the thing. So she didn't necessarily want that. So it hasn't been definitively determined.
Okay. Yeah. She wanted to bend over in front of the jury, drop her pen, be like, tee.
Well, it would work on some people on the panel.
Some.
25% of us, yes.
Yeah.
Okay, can we just talk about this seriously for a second? She's really worried about what she's going to look like.
Yeah.
There's something,
she's a woman.
There's something bothering her. No, she realizes how many people are watching this.
Oh.
Yeah, well,
Like,
I mean, there's...
Well, she doesn't have enough paper clips.
You know that from her letters. She knows how many people have been watching.
She gets it. Like, she realizes that there are legit millions of people watching this. And she's worried. Like, she knows she's aged. And, like, her...
No, I think that's just a woman thing.
Her wrinkles.
All women defendants want makeup and dresses. And...
Don't they normally get makeup?
No.
No.
No?
No.
No.
Did you see Jennifer Crumbly?
Jennifer Crumbly?
Yeah.
She had never looked worse in her life than at that time.
Oh, yeah. Okay.
Yeah, that was bad. That was bad. And like, I'm surprised how difficult this is. Like, you would think it wouldn't be that hard just to chuck a bit of makeup on her, but
they have
It's
rules
really
and
difficult.
procedures and policies.
And it's a security thing, and then they got to get her up there, and they got to get her access.
It's not really a
to
security thing. They're being lazy, and they just cite security as a reason.
Can a paralegal just put it on her face when she's at the table before the jury comes in and court
well,
starts?
that's what they're going to talk about.
Because they'll
even
argue
then-
doing that. They'll argue doing that in front of everybody makes it a spectacle, and there'll be, guys sitting there with his SLR going click, 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 like they'll and those pictures will get out, and it'll just become a circus.
Okay.
Yeah.
Yeah.
But yet she's presumed innocent.
Mm-hmm.
Mm-hmm. All right, let's keep going.
Well, I don't know if we switch it. Does the prosecutor go?
No, that's your table, sir.
That's my table, closest to the jury.
Wow.
So she'll be sitting here with the other two lawyers and I.
Wow.
That's weird. That's really weird.
That is weird.
Normally, just so you guys know, so like the unofficial rule is that the table closest to the jury is for the plaintiff or the prosecutor. And the defendant always sits at the table furthest from the jury. So ideally, then the jury has a better look at the defendant, and there's some weird stuff. But that's
I think it's more of the idea. Oh my gosh, she's the defendant. They're dangerous. She can't be near them.
Yeah.
I think that's the subconscious angle they go for a lot of times.
She might steal a handbag and smack someone with it.
Yeah,
she could.
Like she can't be put near any baggage.
That is weird.
It's a weapon.
I mean, and even Owens is.
Yeah, he was surprised by that.
He was caught off guard. Yeah. So.
And the only time they're going to see her walk in and out is she's always going to be in the courtroom.
And they're going to see her walking in and out.
So the only time is when she testifies. So I guess that I don't know if you have leg restraints that she can wear and walk, but we believe it's not necessary. And of course, we definitely don't want them to see her walking funny or hear something funny or see something funny as she's walking from the defense table to the witness stand to testify on her own behalf. But I don't think it's necessary to have leg restraints. I think once she gets in here in the trial, beginning Monday, jury selection, and I assume the tables are going to stay here.
The privacy panels will be located in front as well, which will prohibit our jury from being able to see any of the leg restraints that she has.
I don't think it's necessary to have the leg restraints, Judge. I think you can bring her in with the leg restraints, but take them off right before we get started. I don't see a problem with that. I don't think she's a threat. There are times when criminal defendants are in a trial and they misbehave in the middle of the trial, so they have to be restrained. But Sarah Boone, as far as I've been involved, and I think prior to that time, has always been polite and cooperative, and she understands the importance of behaving, and I have every intent that she will comply with the court's directive and she will act appropriately throughout the trial. I do not believe any restraints are necessary during this trial.
Okay. Anything further as to that issue?
I don't believe that's case law authority on the issue. Okay, please.
All right, thank you very much. With regard to your request for clothing in that, you can certainly go to the jail and provide, have whoever it is that you want to meet with her in the meeting area to get measurements from her and provide clothing. The clothing for trial will have to be provided to her at the Orange County Jail. That will be brought over with her in the morning, and then she'll be able to be dressed out downstairs.
Okay.
So your motion will be granted with regard to the clothing. You'll have to address with the jail having a person come in there to take her measurements. They may have to be with you, counselor, in order to facilitate that. But the clothing will have to be dropped off at the jail, and it'll be transported
that is actually a
in
problem.
the morning, each day of trial.
That's, believe it or not, that's actually a problem because you've been in jail for 4 years. Well, you're big now. Well, how big is big?
Yeah, I don't know.
You know, like, because, like, what did you used to wear on the street?
Yeah.
She don't fit in that no more. But people also lose weight in jail. Like, I've had clients like, dude, I've lost weight since I've been here. I'm like, okay, well, what were you before? And I look at them and I'm like, okay. And then, like, what size shoes do you wear? You know, but, like, I've had female clients before and I'm like, okay, what dress size do you wear?
That's why you see a lot of defendants that are in street clothes. They're kind of ill-fitting.
Yeah. Kind of shabby looking. Yeah.
The public defenders, you know, lost and found.
I always thought it was because they just went and got stuff from op shops.
That's what we had. Like, when I was in the public defender's office Toledo, we had like a whole rack of clothes that we had gotten over the years. But it wasn't lost and found, but it was like we had bought a shirt. Okay, well, and the guy was done, and we took the shirt back and laundered it, and it was stacked up clothes. You know, or like for some attorneys, they'll go out, okay, fine, I'll spend like, you know, what can I get for $50? Or sometimes for attorneys, going to Goodwill.
Jackets and ties before and different stuff.
Well, there are not a whole lot of clients going to be wearing my jackets and ties. They look like they're wearing their fucking dad's
What do you
clothes.
mean?
But no, you like, but like, I'll also sometimes just like go to Goodwill and get them a nice shirt, and a nice pair of pants, and a nice pair of shoes, and you know, sometimes they let you wear a belt and.
Well, like, no joke. There's a couple Arizona trials that I want to cover locally, and I was at Goodwill the other day, and I was looking at the suits. I'm like, okay, these are like $25 for the suit jacket.
Yeah,
and I'm like, okay, I can just bring a few into the dressing room and see what fits me.
So, what trial did you go to in person? I think Nick was covering it, and you went
yeah, Michael Turney, the one who winked at me.
Directed verdict.
You looked like you were in your dad's suit.
No, I wasn't wearing a suit. I was wearing I spent like $50 at Ross.
But you had a tie or something.
I did have a tie.
You had a tie, but everything was like baggy on you.
A little bit. But yeah.
Regard to the appearance issue, do you have any other further argument as to that?
Judge, just what's stated in the, I made some legal arguments in the defendant's motion for the right to hair, cosmetics, civilian clothing without restraints for trial. Just the arguments in there.
And the Estelle case that you spoke to being dressed out in a prison garb. Doesn't really address a prison guard in shackles. It doesn't address any beautification or anything along those lines.
I just think it's, it's just part of a fair trial.
The other problem is it's contraband. That stuff's not even purchasable at the commissary at the jail, any makeup or anything along those lines.
Well, I'm going to have the two paralegals.
Technically,
here.
it is.
I say,
but once again, that goes to that bullshit argument of security.
Lawyer now, and the other is a consultant. But
so he's bringing it up. Can't we have a paralegal slap some makeup on our face?
Yeah, well, no, because the judge bringing it up, like he knows the jail's going to sit there and scream and cry and go, "My contraband, my security." So,
the females, and they can bring it the cosmetic.
Well, we don't know how they identify, sir. So let's just hold it there.
In and apply it either here in the courtroom or just outside the courtroom. I'm sure there's a waiting room. There's no place where we can apply any.
You can't put them back there because we can't allow access back there. That's for corrections and for the sheriff's department and for the inmates.
Can she be allowed? Can the two females on the team can they be allowed to apply some type of makeup to Ms. Smith?
State?
We don't have any dog in this fight. I've never heard of it happening. That doesn't mean it's not permissible, but
if you want to try to do it here in the courtroom, that's fine. But be advised that when we start court, we start court. So, and I intend on starting it at 9:00 every morning. So I'll have pleas every morning in other matters because the court still has other business at 8:45, and I plan on bringing the jury up at 9 until we select one, and then starting at 9 every day thereafter. So your motion will be granted with regard to the clothing. You can perhaps someone attend, travel to the jail with you, sir, Mr. Owens, to take the measurements. You'll have to provide clothing at the jail. With regard to the appearance, it's denied to have anything happen at the jail or happen in any of the secured areas. But if you want to attempt to have members of your staff apply makeup prior to trial,
That's
you certainly can do
bullshit,
so.
by the way.
Court will provide you a written order with
Secured
regard
area.
to the request to removal of the leg restraints. But the hand restraints will be removed.
Judge, and then something about hair as well.
I think that it falls under the same analysis.
It needs to be done in
There
the
we
Yes,
are.
sir.
How hard is
And then the
it,
last
really?
item teed up for today is the. I'm sorry.
I don't know. It would take me a half hour, but I'm a guy. I've never done it before.
I don't know. It would be kind of cool to see like every day Sarah's like beautification. It could be like they can get super chats for it in the courtroom.
God, it looked like me slapping, like, yeah, it'd be like me and Dave repairing a dent on a Buick.
That's exactly what it would look like.
Card out and just smearing it on. Just kind of leveling it
Start
off.
with
Be
a
like,
heavy application, and then we slowly remove it until you look just like a clown,
just
like-
and then you're good.
This needs clipping. It almost sounds sexual.
Rawr.
but no, it's the secured area, Judge. It's your courtroom. You could do whatever the fuck you want.
Yeah.
Yes.
He's just doing anything he can to make this difficult.
Yes.
Yeah. Well,
He
Ted
is.
Cruz's judge is going to go to Cancun in November 1st, so he needs this just done with.
Hmm.
Am I going to talk about Sticks getting arrested? Yeah, but I need all the docs. I heard he got out. That's all I know.
Corrections in the Orange County Sheriff's Office have just advised me that the concern is if makeup is affixed and then she's taken back downstairs and then taken back to the Orange County Jail, they don't know if it's contraband. They don't know what's placed on her person.
What?
That's the concern.
It's going to be sensational makeup.
Because
Put
their
your
argument
face?
is
But
drugs.
They're gonna put drugs on her face?
Well, they could say. Well, what they're going to say is, how do we know that isn't like cocaine that's been colored and she could scrape it off and sell it to people?
Oh, is that why Nick Riccado was licking Aaron's face?
That's it.
God
Fucking
damn.
A, Dolly, God damn.
You worked it out.
Woo!
You worked
Lord
it out.
child.
See, and
I'm removing myself from
and sheriff's
the
officers
chat.
tell me they can't do it because of the concerns that were just outlined. After she's returned to
Okay, let's
Orange County Jail facility.
Okay.
This is
All right.
ridiculous.
You'll get an order with regard to the restraints no later than tomorrow. Moving now to the state's request for protective order. I've reviewed that. I need to understand what you're looking at, Mr. Owens, with regard to these custodians and supervisors at the state attorney's office.
I did not realize that was going to be addressed
Coco
today.
Chanel.
Yes, my JA had emailed all y'all, I think last week after it was filed, and said this would be added to the hearing for. I guess that was filed on Monday, forgive me. And emailed y'all and said that would be addressed today.
Chat.
That is the chat of the
That was
day.
relating to me subpoenaing the enlisting the. I think it was the.
It's the third amended witness list lists certain people as witnesses: custodian of records, Orange County Office of State Attorney, domestic violence supervisor for the Office of the State Attorney, youth and advocate supervisor for the Office of the State Attorney, and misdemeanor supervisor for the Office of the State Attorney. And the state is seeking a protective order on the grounds that it's work product or opinion product, and requiring prosecutors
Hey,
to
J-Rock.
expose work product and impede criminal prosecutions is violative of Florida law.
Judge, as you know, we have filed a notice of intent for battered spouse in conjunction with self-defense. And we have listed and plan to introduce the fact that Jorge Torres had been arrested, I think, 3 or 4 times prior to this event.
It's still work
And
product.
in
To probably to an
those
extent.
cases, the case was dismissed against Mr. Torres. And it's going to come out that Sarah Boone had requested the charges be dismissed. And I believe it's going to come out probably through expert testimony that that's one of the conditions, or that's one of the things that they try to do, bond you out of bail and then get the charges dismissed as a battered spouse. That's a common
Very
theme.
true.
So ultimately, the jury is going to hear about that, but the jury needs to know it's the ultimate position. The victim doesn't have the final say. It's the ultimate position from the state attorney's office as to whether to prosecute a case or to drop a case. Yes, they are to consider what the victim wants, and they are to consider their request, but ultimately, the state attorney has to make that decision about whether a case is dismissed.
What are you going to be asking from these persons? How would that not be protected by work product?
as to whether or not it was a
if it comes
decision.
out, if it comes out that she
It's
went down
prosecutorial discretion at the end of the day.
and they were dropped, and that gives the impression that she had the power and
I don't think
authority.
that gets you where you're going, man.
And asked the charge to be dropped, and they would. But in fact, the ultimate call is the state attorney's office. They don't have to
I
drop
think
cases.
the only
even if
relevant
it's supposed to
part
do.
here is
So
that
just that
Sarah
decision
asked
by the
them
state
to
attorney
drop
to drop it was their decision.
the charge.
They considered the victims,
Yeah.
but it was their decision.
This doesn't
to drop
change
and their
much.
Power and authority to do so, not the
But it's
victims.
also hearsay,
Okay.
inadmissible.
Response.
Well, it's
Hearsay.
also, I'd argue prosecutorial discretion on top of everything else.
But I mean, you can't even get
That is
Sarah's
absolutely
statement.
protected.
Dahlia, you
I
here?
don't understand why he believes that arrests and dismissals are relevant. What is relevant in a self-defense case is if the defendant is aware of specific instances of violence that the victim has committed, or reputation evidence that can come in from anybody,
Yes,
and it
John.
does not matter whether the defendant's aware of it. The notion that this sort of evidence would be admissible, much less through the vessel of sworn prosecutors, and they have now gone ahead and named people who aren't even involved with the cases. Matthew Storch, Christina Mills, and Aaron McCullough, our head victim advocate, have all now, I learned while we were at the jail this afternoon, been served with subpoenas by the defense, and we're moving to quash those. Prosecutors and victim advocates and other support staff cannot be forced to come in and say why they dropped a case. That is opinion work product. And
Dahlia,
if
would
they
you mind
want to
pausing
get
for a second, please?
public
One.
We might just give a little bit of background to this. There has been a motion to suppress the testimony of some records
Basically,
people.
the prosecutors and the police officers and stuff that were involved in prior domestic violence charges. The charges against
They
the
kept dropping
victim in
them.
this case were dropped. They kept dropping them, and against Sarah too. They kept dropping them, and so they want to call them to say like this and this. There's a history of domestic violence between these people,
Yes.
and that's relevant to the battered wife syndrome or whatever.
Yeah.
And while it could be, the issue is whether or not the prosecutor dropping the charges has any relevance. I don't think it does.
Well,
To the
I think
extent
you could
that these
argue-
people have any relevance at all, relevant testimony would be that Sarah asked them to dismiss the charges, but that's impermissible hearsay anyway. So you can't put that
Yes.
witness on the stand.
which is the bullshit part of the hearsay rule is that, well, you can't introduce your own statements, which I still think is a.
Oh, I do too, but we can't Barnes it up here.
Yeah.
We gotta take the law the way it is. And the law the way it is says
Sarah's already won.
Yes, it's a corrupt judge and a rogue cop.
We can't bonds it up. Very
His argument is the correct one. The judge is wrong, but we
It's
expected
power
the judge
in
to rule this
people.
way.
People power or something.
yeah. So,
And they
but the law
principles.
says is that you can't admit your own testimony. You can't solicit your own hearsay testimony. It's only a party opponent. We could go on and on for that. So they wouldn't be able to call this witness and say, "What did my client tell you?" Because that would be soliciting hearsay. And so
They could-
I don't see how.
I think you could ask, like, did you dismiss the charges?
Yes.
But you might not be able to say why, but I think you could
Why?
demonstrate there's a bit of a. That one's going to be tough anyway, but I think that's what he's trying. Like, that might be a better option. But yes, that's the problem when you get into all this crap of like what's going on. But ultimately, the prosecutor can say prosecutorial discretion. Why? Because I felt like it.
Now, interesting though, if she was being charged with domestic violence as a part of this, then all that would be admissible, I believe. Well, at least it would be under Florida law or Michigan
Exactly.
law.
So the other way around, they can
Even
bring it
the
in.
others, even if they weren't convictions, just we were charging.
Yeah. Yeah.
Yeah.
'Cause you could get in Michigan, you could get in all of that stuff, even if there weren't convictions, even if they were just allegations, police calls and all that stuff.
Yeah.
Well,
Well,
I
and
understand
you'll win if it's against her.
I understand
right?
the allegations, but I mean, like having the prosecutor come in, like, God, that's no.
Well, I mean, I didn't try to call the prosecutor.
No, I know the state did. They were breaking it up.
Yeah.
Records?
Yeah, Barnes it up. Spread it around you, LawTube guys. Barnes it up.
About these cases and try to get them moved into evidence, then they have to do public records requests or compel discovery from the state attorney's office, which I believe we all have. I mean, The state has just been dropped with her medical records that Investigator Lane got in 2021, even though they keep on saying in their amended discovery exhibits that they don't even have this evidence. We got dropped last Friday, the Aspire records and the Advent Health records that have documentation that Billy Lane picked them up in 2021. So the defendants had these things that are getting dropped on the state for years, and we're just getting dropped on us this Friday. And now we are having to combat subpoenas and requests for documents. It is opinion work product. The people that they have listed didn't handle those cases or make those decisions, but that is the ultimate protection, is why we drop these cases. And it's up to the defendant if she wants to come in and say, yeah, I asked to get these cases dropped. I mean, that evidence is coming in anyways through her phone extraction. She is immediately working to bail the victim out. She's immediately working on dropping charges. In fact, there's a video of her coaching the victim on how to drop charges against her on her phone. So all that evidence is going to come in, but it cannot be coming in through opinion work product of the assistant state attorneys and our support staff.
Any further argument?
I didn't make the argument. I did not make the argument that the state attorney was going to be called to ask why they dropped it, as he just referred to.
Hey, Bronco.
Where they had to explain why the case was dismissed. No, the reason for that is just to explain that they have the ultimate power to dismiss, not the victim in a case. Not why we chose to drop 3 cases against Jorge Torres, but they have the ultimate authority. The victim does not control the case. The state attorney does.
Agreed. You have a written order on the motion, protective order for tomorrow, by tomorrow as well. Anything else, State?
Denied. That's what it should be.
It appears, and again, been conducting motions all afternoon.
Protective order, guys.
That we are set to allow the defense to depose our battered spouse syndrome expert at 10 a.m. tomorrow. Yeah. And that will be done virtually.
And that protective order is going to be, those subpoenas are invalid. Boom, gone. That's what that protective order is going to be.
Yep.
Sarah's getting the D for denied.
With regard to the deposition of Dr. Brannon, the deadline is tomorrow.
Just press pause. Okay, because this hearing is like 2 minutes from over, right?
Yeah, that's
cool.
Okay.
All right, so that's cool. Thank you, David, so much for being here. Appreciate
it. Thank you for
very
having
much.
Me.
And
it's always good to hang out with you guys, but I gotta put my wife on an airplane again, so I'm gonna go do that. Yeah.
You go put her on an airplane, then make sure she gets on the airplane fine. And we'll see you next week.
Yeah, I'll be here as often as I can, and
whenever you can.
Sean, are you streaming it live, like as it happens?
I'm gonna try to. Like I said, it's gonna be a month long, so I have like hearings and things out throughout the week, but I'm gonna try to. Yes.
All right.
It's only 2 weeks.
All right. See you guys.
Cool.
See you.
Bye. And Mr. Bronco, you have a link if you want to pop on, but we're nearly done. It's up to you. But I'm going to send you a link every single day, and totally up to you. Also, Steve, everyone's getting links. Everyone's getting links.
Yes, I'm sure you're...
and you.
Yes, I'm sure your wisdom about women and relationships will be much appreciated with chat.
Much appreciated. All right, let's just finish this
Set at 3 p.m.
Okay, that's still set at 3 p.m.
Yes, there will likely be a pending motion to strike if his testimony is duplicative with Dr. Harper's. My understanding from the defense is he's just going to explain what battered spouse syndrome is. It's unclear why or how that would be different than Dr. Harper explaining that.
Is that taking place here, or is that taking place in South Florida, virtually?
Unfortunately, due to time constraints, I cannot be everywhere at all times.
Okay, all right.
Judge, and then on Dr. Brannon's deposition, yes, it's set for 3. I'm just learning now that the expert is going to be available at 10, Gall's expert, by Zoom. And we did talk about that at the jail, trying to schedule something for tomorrow.
Don't post the Zoom link.
She just evaluated Sarah Boone
that'd be great.
Me too. And then I'm going to take her.
They're not doing that anymore.
Morning by Zoom. And then we're taking Dr. Brannon's
Next time,
deposition.
J-Rock.
If they file some type of motion about that, then of course I'm going to respond.
You're welcome always, J-Rock, too.
Okay. Go ahead. I'm sorry.
Those 2 things are the only 2 things that I believe we have left prior to jury selection on Monday.
Okay. If any motions are filed by anyone moving forward, please favor a copy to my judicial assistant upon filing. And if there's any authority that you intend on arguing that's not cited in the motion, please provide me that authority as well. Although it is a court holiday, the court will be working tomorrow. I will endeavor to get you written orders on all of these things no later than the close of business, hopefully earlier than that by tomorrow. On Monday morning, State, if you could please bring a copy of the score sheet so that when I colloquy Ms. Boone prior to trial about the charge, the potential penalties, everybody's on the same page as to what those are. Okay?
Yes. And if y'all could send me that, I'll go out to the jail. I'm going to be here.
If you could favor him a copy of that tomorrow or Friday so that he has the opportunity to review that score sheet with Ms. Boone in advance.
Yes, and we're going to be filing a motion in limine to exclude the battered spouse syndrome testimony that will need to be addressed. Just waiting to see now how the depositions pan up tomorrow, but based on what we witnessed this afternoon, it's the state's position that we're going to need to file a motion in limine.
Okay, all right, appreciate it. All right, thank you all very much. We'll address scheduling of any motions on Monday, and it may be a circumstance where, as the court had identified earlier, that we're just going to be looking at cause issues and what people may know about this case. That'll be happening before we turn it over to you all, which would include, Mr. Owens, your opportunity to voir dire on any defenses that may be being raised in this case. So it may be, we may get a panel and then ask them to come back later in the week so that we can have those motions after we get that panel of 50, once we deal with all the cost challenges. Okay? All right, thank you all very much. We'll see you Monday morning at 9 a.m. Court's in recess. Thank you.
There you go. There you go. Alrighty. Well, you know what's going to happen now, don't you?
Yes.
You know what's going to
I
happen
gotta
now.
get going. I'm sorry.
Oh, you're going to miss out.
I know. I'll be in chat.
Okay. All right, here we go. Sean and I can do it together then. That's all right. Here we go. Hang on.
Right. Bye, guys. Thanks.
Yep.
Bye, darling.
Godspeed.
Okay. Let's just make this happen. Right. I need to get rid of all the things on the screen though. Alrighty. Everybody needs to be in chat now. And I need to get rid of all the weirdo things that are sitting on top. Where are we? You know we're 4 away, but that's okay. No, 4. Yeah, we're 4 away from there being another thing on the screen next time. So that will be when there is the trial next week. So I'm keeping track, guys. I'm keeping track. Now, Sean, you've never done this before. You're muted. Oh, hang on. Am I muted? Oh, no. Yeah, you're muted.
Sorry.
Hello? You're right.
I'm back.
Never done this before with me.
No, I'm not.
Oh, well, guess what? We are doing Boone and Swoon pre-trial quiz. Now, if you want to play, you can, but you can't put your answers into StreamYard because that gives you an unfair advantage. All right?
So I have to go open up on my own. Okay.
Do it on your mobile or somewhere else. All right? Cool. Yeah, because it goes through quicker otherwise if you do it in StreamYard, right? But everyone can play now. Guys, if everyone gets the right answer, if lots of people get the right answer, it's about how fast you get your answer in. Okay, so lots of people playing today, so you never know. We might have lots of people getting the right answer. So make sure that you get in quick. There's only 5 questions today. Let's see. So the detective said she saw Sarah's phone where? 1, on the table. 2, on the floor. 3, on the counter. 4, in the suitcase. Put your answers in chat. 1, 2, 3, or 4. 1, 2, 3, or 4. The detective said she saw Sarah's phone where? 1, on the table. 2, on the floor. 3, on the counter. 4, in the suitcase. 1, 2, 3, or 4. Put your answers in chat. Ooh, let's see. It can kind of work if you follow other people, but that means that other people get there quicker than you. And they might be wrong. You never know. They could be wrong. Computing. Not intentional.
Sarah Boone needed a lawyer.
She needed a lawyer.
I just got a feeling.
Reach around.
Oh, it's thinking. It's adding all the people up. What's it gonna do? Oh, Masha! And then Maddie! And sorry, Bob! And sorry, AG! KLF! Half Irish, Old Line Red, Unbronzed, and 11 others made it. Why did Sarah go and stay with her ex-husband the night she reported George dead? 1, to be with her son. 2, she was terrified of his family. 3, she wanted to get back with her ex. 4, she left her stuff there. Were you paying attention? Why did Sarah go and stay with her ex-husband the night she reported George dead? 1. To be with her son. 2. She was terrified of his family. 3. She wanted to get back with her ex. Or 4. She left her stuff there. 1, 2, 3, or 4. Put your answers in chat. Now.
Reach around.
In the land down under, where kangaroos roam, there's a lady named Hell with a heart of gold.
This is my alternate song. Yeah. Ooh, how many people got it? I see some different things going on.
I just got a feeling.
Ooh! She was terrified to be with his family. That's right, Maddie, KLF, Deanna, all in red by Franz. Oh, that was quick. Sarah said, when law enforcement arrived, she was worried about what? 1. George. 2. Her wine. 3. Her phone. Or 4. Her dogs. 1, 2, 3, or 4. Put your answers in chat. Sarah said, when law enforcement arrived, she was worried about what? 1. George. 2. Her wine. 3. Her phone. Or 4. Her dogs. Which was it? And which wasn't it? Yes. What do we think it could be? La 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 da 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 da.
I just got a feeling.
Her name was
Sarah Boone needed a lawyer.
She really did.
She did more than we know.
Oh yeah. Imagine if she was still on her own. KLF, Marsha, Mavka, Maddie, all in red. Sorry, David, and potentially criminal.
Oh, she's better than I thought she was as a human being.
Yeah, exactly. In the squad car, Sarah said Detective Koppel told her she would be asking 1. Multiple choice, 2. Just general questions, 3. About the autopsy, or 4. About a homicide. In the squad car, Sarah said Detective Koppel told her she would be asking 1. Multiple choice, 2. General questions, 3. About the autopsy, or 4. About a homicide. In the squad car. What
Squad
was
car.
in the squad car? 1, 2, 3, or 4 in the squad car. In the squad car.
The squawker.
The squad car. Yes. Now we are up to question 4 of 5, everybody. We're nearly there. We're nearly there. Oh, potentially criminal gave a $5 super chat. Thank you so much, potentially criminal. This is a South African accent. You like it? I have diplomatic immunity.
You gotta wave it like in a diplomatic immunity.
Yeah, diplomatic. Masha.
It's just been revoked.
It's Travion, sorry. Sorry about that. Never mind. Okay, the court reporter had what sitting on the floor next to her? 1, a suitcase.
Now?
2, a shoebox. 3, a laptop. Or 4, a banker's box. The court reporter had what sitting on the floor next to her? 1, a suitcase. 2, a shoebox. 3, a laptop. Or 4, a banker's box. Were you paying attention? Were you paying attention? 1, 2, 3, or 4. I love these. These are always my favorite. I really enjoy the observation questions. A human head, Bob.
Oh,
Hello, Dina. What you want?
what's that?
Is Dina saying hi?
Oh,
I don't think many people are going to get this. No, I wasn't going to ask about... I don't ask about colours every time. Oh, yeah, AG! Cat Madison and MLS! It was actually a suitcase! She had a suitcase! I'm not kidding! No, Half Irish is not going to win today. Check it out, everybody. Look at that. Look at it. I hate it the way it cuts off the bottom line. Cat Madison came first, and then KLF,
wow.
then Maddie B, then Old Line Red, AG, That's a Shame, MLS.
I don't think I got
Colleen,
any
Marsha.
right.
Well,
Scroll down.
you might. Nah. You didn't make the leaderboard. It can only fit so many people on the leaderboard.
Oh no.
Oh no. Oh wow, that's awesome. Okay. Yeah, I don't know why it tries to fit a fourth line when it can't actually fit a fourth line. I have talked to the developers about that. I'm like, why does it try and do that? But at least we can kind of see where that many people are. All right. Cat Madison, you're a new winner. Well done. And KLF and Maddie B, I think that's the first time for all three of you. All Line Red, you are used to being up very high in the list. Well done. Well, welcome to all the new people who have played for the first time. And so, no, it's not rigged so Half Irish wins. Half Irish has come 12th. Thank you for the super chat, though, David. And thank you for being here today. I really appreciate it. And for everyone being here who's new. Now, I wanted to just say that... there we go. I wanted to just say thank you very much to Sean for being here. Sean, you have a stream very soon.
Yes,
so
we're doing
I'll let
members
you go.
only. 9:30.
Yep.
We're gonna be hanging out, watching stuff, having a good old time.
Yep, absolutely. And what else you got on this week?
Well, tomorrow night we've got the show, the normal weekly show. 9:30
What,
Eastern.
sorry?
The only time zone that matters. American Eastern Standard Time, not Australian.
Oh, the crime stream.
Yes. And we got there's a lot to talk about. Like there's some very interesting things. Like Diddy has some very interesting things going on. And then also a guy has gone to federal prison for cloning super sheep so he can hunt them.
Super sheep.
Yeah, he was breeding he imported sheep from like Siberia and was trying to breed them with sheep to make like challenging hunts for like a hardy sheep that works better in the mountains, and he got sent to prison for that.
Wow. Okay. That's
it's 'cause he
amazing.
imported animals illegally, but that's a bigger issue than anything. So
Oh,
we'll get to that. We'll get to that. We got some other stuff to do too.
Okay. And also with your Boone coverage, just tell us again what you're planning on doing.
I mean, it's really going to be, guys. My schedule is just kind of there's so many things that are happening that, like, Monday I'd be able to do it. Tuesday it'd be kind of hit or miss, and then like Wednesday, it's going to be from day to day. I'm going to have to give you guys a schedule look, but there'll be days where I'm probably not going to be able to cover it.
Yeah.
So.
All right. Well, I'm hoping that, live, I'll be definitely telling people who are over here, if you want to see it live, go over to Potentially Criminal, and go watch it during the days, because definitely that's something I certainly can't do. I'm asleep, getting my beauty sleep during the US days, because, that's what I do over in Australia. And yeah, my coverage will start from 6 p.m. Eastern every evening on fast mode. So that's the only way. I haven't covered a trial in a really long time. So yeah, first time for a while. Thank you, Sean, so much for being here. Really appreciate it. It was super fun, wasn't it?
Great. I very much enjoyed myself.
Good. And yeah, your input's always really helpful. And David out there, thank you so much for being here too. Branka in chat, hoping to have you on at some point in time, definitely to talk about the battered spouse defense as well. But just because you're a mate and I haven't seen you in a bit. And Gosney, my friend, I know you're working super hard in your new job, but yeah, hoping to have you on too really soon. Guys, we're going to raid my Aussie friend Ping, and love you all to go and say
Wait, your
hi to
name's
him and
your
say,
friend, what's their name?
his name's Ping. P-I-N-G.
I said Peen. I'm like,
no, not Ping. His name's Ping, P-I-N-G. He'll be super excited to see everybody.
One
so
Pringle.
please, everybody, say excited utterance raid, EU raid, hello raid, whatever you want to say. But say hi to him for me, please. He's a lovely guy, and his channel is doing really, really well. So say hi to him, and his viewers will come back and see us as well. So that will be really nice. Love you all, and here is no, it's not Peen Day. It's Ping, P-I-N-G.
I told you I wasn't the only one.
I'm sorry, it's my accent, man. All right, here's my song now. It's time to go.
Her name was Helen. She was an Aussie. She was a fake lawyer from the future. She got on YouTube and made some live streams. The co-host is Dolly and she dances sometimes. The words are always so loud and because she's an 803. To the attention, excited utterance. A cat is staring through any north, listen